Ladies and
Ladies and
gentlemen,
gentlemen,
now with the
now with the
permission of the
permission
chair,
of the
may
chair,
I
I
proceed with
proceed with
today's
this
listener.
listener.
A very good morning to all of you. As we all know that
That
2020 has vandalized us
vandalized
with an unprecedented crisis of COVID-19 pandemic.
pandemic.
With numerous confirmed cases and casualties so far, we are forced to face one of the biggest crises of our times. Apart from issues relating to medical and social aspects, a new set of issues has arisen in the world of law and justice, which needs immediate action. In this backdrop, Honorable Juvenile Justice Monitoring Committee of Patna High Court conceptualized to have its very first webinar on the issue of juvenile justice. Now, without any further dawdle, I, Saurabh Singh, Research Officer, Juvenile Justice Secretariat, on the behalf of Juvenile Justice Monitoring Committee, extend our most cordial welcome to Honorable the Chief Justice, Patna High Court, Honorable Mr. Justice Sanjay Karol, for sparing his Lordship's valuable time for today's webinar. I also tender my heartiest welcome to Honorable Mr. Justice Ashwani Kumar Singh, Chairman, Juvenile Justice Monitoring Committee, Patna High Court, Honorable Mr. Justice Vikas Jain, Judge, Patna High Court, Honorable Mr. Justice Ehsanuddin Amanullah, Member, Juvenile Justice Monitoring Committee, Patna High Court, Honorable Mr. Justice Secretary Sharan Singh, Judge, Patna High Court, Honorable Mr. Justice Ashutosh Kumar, Judge, Patna High Court, Honorable Mr. Justice Arvind Srivastav, Member, Juvenile Justice Monitoring Committee, Patna High Court, and Honorable Mr. Justice Rajiv Ranjan Prasad, Judge, Patna High Court. Ladies and gentlemen, with great reverence and admiration, I also welcome all the honorable judges of Patna High Court and honorable judges of all the high courts of various states viewing this webinar at the moment. With all due regard, I also welcome all the participants viewing us at this moment. Ladies and gentlemen, now before proceeding towards the beginning of the webinar, I would humbly request Honorable Mr. Justice Arvind Srivastav, Member, Juvenile Justice Committee, Patna High Court, to give the welcome address. Your Lordship.
माननीय मुख्य न्यायाधीश पटना उच्च न्यायालय श्री संजय करोल, माननीय श्री अश्विनी कुमार सिंह, न्यायाधीश पटना उच्च न्यायालय, सह अध्यक्ष जुवेनाइल जस्टिस मॉनिटरिंग कमेटी पटना हाई कोर्ट, माननीय श्री विकास जैन, न्यायाधीश पटना उच्च न्यायालय, माननीय श्री एहसानुद्दीन अमानुल्लाह, न्यायाधीश पटना उच्च न्यायालय, सह सदस्य जुवेनाइल जस्टिस मॉनिटरिंग कमेटी पटना हाई कोर्ट, माननीय श्री चक्रधारी शरण सिंह, न्यायाधीश पटना उच्च न्यायालय, माननीय श्री आशुतोष कुमार, न्यायाधीश पटना उच्च न्यायालय, माननीय श्री राजीव रंजन प्रसाद, न्यायाधीश पटना उच्च न्यायालय व इस वेबिनार में आमंत्रित पटना उच्च न्यायालय और अन्य सभी उच्च न्यायालयों के माननीय न्यायाधीश गण, श्री अतुल प्रसाद, अपर मुख्य सचिव समाज कल्याण विभाग, श्री विनय कुमार, अपर महानिदेशक वीकर सेक्शन, श्री राजकुमार, निदेशक समाज कल्याण विभाग, सभी जिला एवं सत्र न्यायाधीशगण, निदेशक बिहार जुडिशियल एकेडमी, सदस्य सचिव बिहार राज्य विधिक सेवा प्राधिकार, सभी पीठासीन पदाधिकारी चिल्ड्रंस कोर्ट, सभी मुख्य न्यायिक मजिस्ट्रेट, सभी प्रधान मजिस्ट्रेट व सदस्यगण जुवेनाइल जस्टिस बोर्ड्स, राज्य सरकार के वे सभी पदाधिकारीगण जो इस वेबिनार में आमंत्रित हैं, पटना उच्च न्यायालय, बिहार जुडिशियल एकेडमी, बिहार राज्य विधिक सेवा प्राधिकार व सचिवालय जुवेनाइल जस्टिस मॉनिटरिंग कमेटी के सभी पदाधिकारीगण व इस वेबिनार से श्रोता के रूप में जुड़े सभी न्यायिक पदाधिकारीगण। मैं अरविंद श्रीवास्तव, जुवेनाइल जस्टिस कमेटी पटना हाई कोर्ट की ओर से आप सभी का स्वागत व अभिनंदन करता हूं। मैं माननीय मुख्य न्यायाधीश श्री संजय करोल का विशेष रूप से अभिनंदन करता हूं कि उन्होंने इस वेबिनार के लिए हमें अपना बहुमूल्य समय दिया। आप में से बहुत लोगों ने पूर्व में आयोजित सेमिनारों में हिस्सा लिया होगा। कोविड-19 पेंडेमिक की वजह से हमें सेमिनार के बजाय वेबिनार का आयोजन करना पड़ा। जो लोग पहली बार इस सेमिनार या वेबिनार से जुड़ रहे हैं, उन्हें मैं बताना चाहूंगा कि इस सेमिनार या वेबिनार का आयोजन क्यों किया जाता है। जुवेनाइल जस्टिस एक्ट 2015 की धारा 4 क्लॉज 5 व धारा 108 क्लॉज बी तथा बिहार जुवेनाइल जस्टिस रूल्स के नियम 4 क्लॉज 6 व 89 के अनुसार राज्य सरकार जुवेनाइल जस्टिस बोर्ड्स के प्रधान मजिस्ट्रेटों व सदस्यगणों की नियुक्ति के 60 दिनों के अंदर व इस अधिनियम से जुड़े राज्य सरकार के पदाधिकारी गणों को सेमिनार या कॉन्फ्रेंस के माध्यम से अधिनियम के उपबंधों के विषय में प्रशिक्षित करेगी। इसलिए नियमित अंतरालों पर इन सेमिनारों या कॉन्फ्रेंसों का आयोजन किया जाता है। अधिनियम का उद्देश्य एक ऐसी संवेदनशील व्यवस्था का निर्माण करना है जिसका प्राथमिक उद्देश्य बच्चों का हित है, चाहे वह उनकी देखरेख, सुरक्षा, विकास या अवसर से जुड़ा हो या उनके अधिकारों, चाहे मूल या से जुड़ा कोई मामला हो। इस वेबिनार में आज हमने मुख्यतः 3 विषयों का चयन किया है जिनके बारे में हमारे माननीय वक्तागण आपको विस्तार से बताएंगे। माननीय अश्विनी सिंह जी, जो हमारे समिति के अध्यक्ष हैं, अपने मुख्य संबोधन से पूर्व अधिनियम और आज के विषयों से आपको परिचित भी कराएंगे। पूर्व के सेमिनारों में हर संबोधन के बाद एक छोटा सा प्रश्न काल भी होता था जिसमें वक्ता से प्रश्न भी आप पूछ सकते थे और आपको तत्काल उसका समाधान भी मिल जाता था, किंतु इस वेबिनार में तकनीकी कारणों से यह संभव नहीं है। लेकिन यदि आपके मन में कोई शंका है या कोई प्रश्न है जिसका समाधान आप चाहते हैं तो हमारी कमेटी के सचिवालय से संपर्क कर सकते हैं। उनके फोन नंबर, ईमेल एड्रेस नेट पर उपलब्ध हैं। एक बार मैं पुनः इस वेबिनार में शामिल होने के लिए आप सभी का अभिनंदन व स्वागत करता हूं और आशा करता हूं कि आप इससे लाभान्वित होंगे। धन्यवाद।
Thank you, Lordship, for the welcome address. Ladies and gentlemen, now may I invite Honorable Mr. Justice Ashwani Kumar Singh, Chairman, Juvenile Justice Monitoring Committee, Patna High Court, to give an introductory address for this webinar. Your Lordship.
Honorable Chief Justice Sri Sanjay Karol, brother judges of Patna High Court, and all those joining us from the other high courts across the country. Registrar General, Patna High Court, members of registry, including the Additional Registrar and Research Officer of Juvenile Justice Monitoring Committee, Director and other judicial officers of the Bihar Judicial Academy, Member Secretary and other judicial officers of the Bihar State Legal Services Authority, District and Sessions Judges Bihar, Presiding Officers of Children's Courts, and also those judicial officers joining us from other states, Additional Chief Secretary, Department of Social Welfare, Government of Bihar, ADGP Weaker Section, Government of Bihar, Range IGs, Senior SSPs and SPs of the State of Bihar, Principal Magistrates, JJBs, Social Members, JJBs, Chairpersons and Members of State Child Protection Society, Chairman and members of CWCs, probation officers of all districts of the state, assistant directors, district child protection unit, members of press and media, ladies and gentlemen, a very good morning. It is my pleasure to be a part of this initiative where, in spite of the challenging times that the world is witnessing amidst coronavirus epidemic, or you say pandemic, all the relevant stakeholders have congregated in this webinar with the sole object to alleviate the hardships being faced by the children in institutions, including but not limited to observation homes, special homes, and places of safety. Ladies and gentlemen, India has the distinction of having the largest child population in the world, with approximately 450 million children under the age of 18 years. In any crisis situation, be it natural disaster or pandemic, the children, especially those who belong to socio-economically backward class, end up becoming the most vulnerable demographic. On March 23, a bench of the Supreme Court, led by the Honorable Chief Justice of India, directed the states and the union territories to constitute a high power committee to consider granting parole or interim bails to convicts and under trials in order to prevent the spread of coronavirus in jails. The bench observed that the prisoners convicted of or charged with offences attracting jail term up to 7 years can be considered for this exercise aimed at decongesting jails. On 3rd April 2020, a two-judge bench of the Supreme Court took suo motu cognizance of the issue involving protection of children who fall within the ambit of the Juvenile Justice Act 2015 and issued directions to various authorities to protect children in protection homes from the spread of coronavirus. The bench asked the JJ boards to consider taking steps to release all children alleged to be in conflict with law on bail, unless there are clear and valid reasons for the application of proviso to section 12 of the Act.
What is proviso to section 12 of the Act? I leave it upon Brother Asutosh to explain, who will be addressing us on the first topic today in the webinar.
The bench also asked the authorities to ensure that counseling services were provided for all children in the observation home. In spite of this, there are news reports about children being tested positive in protective homes at Kanpur and Chennai. In this regard, the Supreme Court has sought for status reports from the state of Uttar Pradesh and Tamil Nadu, respectively. The Juvenile Justice Monitoring Committee of the Patna High Court is conscious of the fact that children alleged to be in conflict with law, living in unsanitary and crowded conditions in observation homes and places of safety are at heightened risk. Our priority is to find ways to tackle these challenges amidst the pandemic. Keeping this objective in mind, the Juvenile Justice Monitoring Committee of the Patna High Court has chosen to organize this webinar for the purpose of bringing together different aspects of the interaction between juveniles and the legal system. I am grateful to Honorable Chief Justice not only for accepting our invitation to be the chief guest for the webinar at a very short notice, but I must tell you that when I gave him a call about a week back, telling him about our plan to have this webinar, he not only encouraged me and encouraged, in fact, the Juvenile Justice Committee, but also extended all his cooperation and good wishes. He also assured that if we choose to have a webinar at a much bigger level, he would be available always for extending all kind of support to us. Honorable Chief, I'm really grateful on my own behalf, as also on behalf of the Juvenile Justice Monitoring Committee, as also on behalf of Patna High Court. I am sure, Honorable Chief, your presence at the webinar and your inaugural address would be a source of inspiration for all the stakeholders of the juvenile justice system. Thank you all. I hope this webinar enlightens each one of us to create a better environment for children. Thank you once again.
Thank you, Your Lordship, for the introductory address and setting the tone for this webinar. Ladies and gentlemen, now may I humbly request Honorable the Chief Justice, Patna High Court, Honorable Mr. Justice Sanjay Karol, to give the inaugural address of this webinar. Your Lordship.
I'm catching up with technology. God is kind. I'm sorry for the glitch. I don't know. I was obviously not audible, but I said that with the permission of God Almighty, I shall begin. My esteemed colleagues and Honorable Mr. Justice Ashwini Kumar Singh, Chairman of the Juvenile Justice Monitoring Committee, his energetic team, Honorable Mr. Justice Amanullah, Honorable Justice Arvind Shrivastava, and the panelists whom I can see smiling on this screen. Obviously, my learned brothers of this court are with us. And as I understand, the members of the legal fraternity, as also the academia, all of the world is there with us today. What a great moment it is. Thank you, Brother Ashwini. To begin with, I must congratulate you for one thing. And it is that you have made my dream of making the judiciary and the courts of Bihar as #1 in the country come true. Today is yet another milestone in that direction. Ladies and gentlemen, Honorable Mr. Justice Ashutosh, Honorable Mr. Justice Rajiv Ranjan Prasad, Honorable Mr. Justice Ashwini Kumar, who are here today. I am sure you will be enriched with their views. But I must, at this point in time, compliment Honorable Justice Ashwini Kumar and his team. I must tell you, you're the first court in the country, the Juvenile Justice Monitoring Committee, the first one in the country who have organized this webinar. My felicitations and greetings, congratulations to all of you. With this tone, I'll begin. Yesterday, I saw a video of two young boys belonging to different background walking together holding hands in the US. That video was being celebrated as an example of true spirit of humanity that does not discriminate along the lines of caste and orientation. But what is interesting for me was that both the children were wearing their face masks. That, according to me, is an indication that sometimes children lead the way forward and show us what is best for humanity, and especially in the current times of COVID-19. What made me reinstate my faith that children are indeed the citizens of tomorrow is this snapshot. I've just sent it to Brother Chakadhari. I don't know whether it can be uploaded or not, but just see if it can be during the course of the webinar, it can be so. But the future of the children is dependent on how we treat them in the present time. times. When I came here, I said that Bihar is a great, according to me, motherland. All civilizations, different civilizations over a period of time, different religions, different cultures were born and evolved in this great land. Buddhism, Jainism, Sikhism, everyone has seen the culture and the traditions go. Brother Ashwini pointed out that we have great challenges also. I have been saying right from the very beginning that 1/10 of India lives in Bihar. And as per the 2011 census, 30% of India, 30% of the population of Bihar is below 14 years. And about 40% is below 20 years. How do we treat them? How does a nation deal with the delinquent in relation to, according to me, the ideologies of the society and the strength of the rule of law? For me, I was just tracing how the juvenile justice laws have evolved world over. It took 2 centuries across the nation for the law to evolve, right from 19th century till the UN declaration came. In India, when the Britishers came, that was the first time when the law was really enacted. And since then, till the Constitution came, there were just about 5 legislations. It was only in the year 1986, and between 1986 and 2015, we saw an umbrella legislation which was brought in to take care of these young ones. Now, having said that, I must also say this, that the Act imposes a great duty upon us. What is it that we want to see India evolve as? And in my considered view, that each one of us, more so the child, we must instill this respect for law and not fear of law of God or of God. It is the constitutionalism, it is the idea of this great nation, it is the ideals which the constitution makers have enshrined there in the constitution. We must instill them in each one of the child, so as to when they step out and lead of the reins of the nation, they must have the respect and love for the constitution, its principles, as also this great nation, and also have compassion for all living beings. It is our duty, it is the duty of the state, it is the duty of the society also to see that we have a bright future for these children, and that would only help India become a great superpower once again. We are guardians, the law provides, the law mandates, law has set up various institutions, infrastructure which we have to take care of, and the challenges, according to me, which Brother Ashwini has already highlighted, is understanding and applying the law as it exists in true letter and spirit. And all this, I'm sure, we can do together by having an inclusive association and participation of all concerned, including the lawyers, the members of the legal fraternity, the Legal Services Authority. Of course, Juvenile Justice Board is doing a great job in Bihar, there's no doubt about it. But we have to reach out to those, not only we have to work for those who come to us, but we have to also step out and reach out to those so as to see that the provisions of the Act are implemented in letter and spirit. The deprived ones, the marginalized ones, the downtrodden ones, and those who are left out must be brought back into the national stream. Then only we'll have this great eye of unified great nation. Friends, I'm sure during the day, all of you would be enriched by the views which should be expressed by my colleagues. I'm sure the civil officers, the state, and outside the state would be benefited. I would only request them that please patiently listen to our brothers. And I'm promising you, gentlemen, that I'm also going to sit throughout the webinar and listen to you, because education is something which comes each day, each good. I would also be benefited and enlightened by your views. Judges, I must say, whether you are dealing with the cases inside the court or outside the court, you have to show compassion, you have to show maturity, to show positivity and sensitivity, and you have to heal the matter, the point of view of the child, and see it from. And that is how I would request the happiness portion, the emotional portion of each one of the child has to be. And I'm patiently listening, patiently waiting to listen to the views of my brother Ashwini, who would tell us how yesterday's chocolate child would continue to live with dignity and pride in the unprotected environment society. Also patiently listen to Brother Ashutosh would have to say whether the state or the society was best suited to whom child can become a happy, law-abiding citizen of this nation. Also, listen to our brother Raji. I have to say how the flora and the fauna we brought in can bring in brightness and compassion in the lives of each one of us, not only within the presence of the judicial complex, but also outside. With these words, gentlemen, I congratulate Brother Ashwani and his team again and wish success to all of you. These words. Thank you very much.
Thank you, Your Lordship, for the inaugural address and for enlightening all of us on the concern for children in the present scenario. I also thank Your Lordship, Honorable the Chief Justice, for all the support and guidance for holding this today's webinar. Ladies and gentlemen, now may I humbly request Honorable Mr. Justice Chakradhari Sharan Singh, Judge, Patna High Court, to take over the charge of this webinar as a moderator for the technical sessions. Your Lordship.
Honorable Mr. Justice Sanjay Karol, the Chief Justice cum Patron in Chief, Bihar. Mr. Justice Ashwini Kumar Singh, the Chairman, Juvenile Justice Monitoring Committee, Honorable Speakers on the panel, Honorable Brother Judges of this court who have joined this webinar, learned district and sessions judges of different jurisdictions, the Registrar General Patna High Court, the ADG Weaker Section, Bihar, the Additional Chief Secretary, Social Welfare Department, Government of Bihar, the Member Secretary of Bihar Legal Service Authority, the Director, Bihar Judicial Academy, the judicial officers who are participating in today's deliberations, officials of the state government, the representatives of the UNICEF, if any, the office bearers of the Juvenile Justice Monitoring Committee, other participants, ladies and gentlemen, a very good morning to all of you. The tone of today's webinar has been set with the inaugural address of Honorable the Chief Justice and the introductory remarks made by Honorable Mr. Justice Aswini Kumar Singh. It is truly a very encouraging beginning. We often say that morning shows the day. With the kind of the panel of speakers which we have today and the way in which the tone has been set, the webinar is bound to be immensely beneficial for all of us. Who among ourselves is unfamiliar with a very common way of pardoning for his mistakes or even his misdeeds by saying, "Abhi bachcha hai, samajh nahi hai, sudhar jayega." He is a child who doesn't understand and will correct himself. I am sure every adult must at some point of time in his or her childhood have been benefited of this expression used either by father, mother or any elder family member as a guardian or all of them. This simple looking expression has a great philosophy behind, which is in my opinion the foundation of juvenile justice system worldwide. There is a second situation which is more unfortunate for those who might not have had this benefit of a strong protective umbrella in the name of parents or guardian or otherwise, either because of their absence in their childhood or because of incapacity of their parents of any kind. This first situation is juxtaposed to a child in conflict with law if any act of his or her is punishable offence, where the state assumes the role of parens patriae. Loosely speaking, though, the second situation is comparable with a child in need of care and protection. Here also, the state assumes the same role. These are two broad classes of children whose welfare the statutory provisions under the Juvenile Justice Act aim at. The act is an exhaustive, self-contained. The topics selected for today's seminar cover almost all practical aspects which we deal with in the process of administration of the statutory provisions under the Act. Brother Mr. Justice Asutosh Kumar, in his address on the first topic, is going to elucidate synchronization of a juvenile's right of his release on bail who is in conflict with law in terms of Section 12 of the JJ Act with the principle of deinstitutionalization, which is 12th principle of Section 3 of the JJ Act, applying best interest of the child principle, which is the 4th principle of Section 3 of the JJ Act. Brother Justice Rajiv Ranjan, dealing with the second topic, will be focusing on the importance of maintaining a child-friendly environment during inquiry or trial that can be perceived in the sense that it does not only minimize the challenges that children face at each step of a legal proceeding, but also limits the traumatic experience which a child may encounter in the legal system, and as a result, it can also secure children's rights to access to justice. Lastly, the final topic is going to be addressed by Brother Mr. Justice Aswini Kumar Singh, the relevance and scope of this topic can be perceived in the sense that it stipulates a situation where a juvenile is to be tried as an adult, and it raises a question whether principles of Juvenile Justice Act will still be attached to such juvenile though tried as an adult. Further, the proposition of law in reference to the remedy of appeal in cases of preliminary assessment by juvenile justice boards will also be part of this session. Most importantly, in this session, Brother Singh would discuss the approach and attitude expected of a court conducting the trial of a juvenile as an adult. With these notes, may I request Brother Ashutosh to address us on the topic.
Thank you, moderator sir. Thank you so much. A very good morning to all of you. My special courtesies to Honorable the Chief Justice and Chairman and the members of the Juvenile Justice Monitoring Committee, and to all my brother judges who have logged in. I also warmly welcome all the attendees. I am not specifically taking their names because it would eat away into my time and I have to maintain that time limit of 40 minutes. Honorable Justice Secretariat Singh, as a moderator, has said something which makes me feel and tempts me to say that as a moderator, he has behaved like a loco parentis. Bacha hai, abhi sikh jayega, not to bother. Now, this is actually what we are supposed to think and act upon while dealing with children. Now, without much ado, I'll straight away come to my topic because there are some concepts involved here, and I need to speak on those concepts in a holistic way because the topic cannot be dealt with individually. Two elements are there in this topic: synchronization of the concept of deinstitutionalization and right to bail under the JJ Act. I'll be rather brief in referring to the Act as JJ Act and not Juvenile Justice Care and Protection of Children Act 2015. So these two institutions, these two concepts are so interwoven and intertwined that they ought not to and should not be treated differently. This is how I would begin. I would let you know what do I understand, what is the general understanding of these terms, and how it is to be translated into actual administration of the JJ Act. Now, before I say that, I must sort of specify that if the provisions of the JJ Act 2015 is seen with some care and concentration, it will become obvious that the concept of deinstitutionalization is inherent in it. The provisions of the Act inheres within itself the elements of deinstitutionalization. As a child is seen as a seed who matures into an adult. Likewise, every idea also begins with a seed of thought. Now, the seed here is the feeling which crept in the mind of the monitoring committee all over the High Courts, and especially of Justice Aswini Kumar Singh, who is the chairman here, that the JJ Act can be better administered if the concepts are made clear to the stakeholders and position of law is also succinctly stated. There are some gray areas with respect to navigation of the provisions of the Act which are beneficial, which should work for the benefit of children. Now, this feeling is the result of a wake-up call, wake-up call in alarm. Now, what is this wake-up call? Along with this wake-up call, simultaneously, we would like to be reminded about the relevance of a snooze button. The snooze button which is there in every alarm to put off the alarm bell. The loudest voice today is the ringing of wake-up calls. Why I am saying so, I'll let you know in a second. When you hear of a young man who has had a heart attack, you know it's a wake-up call for you to start physical work, to get onto the treadmill and get back to the fitness mode. When you hear of a crash of big companies on the Wall Street, you immediately find that Indian banking majors, they start giving you calls for loans. When you read about divorce, the increasing number of it in metros, you straight away think that you have to spend more time on your home front. So this is the wake-up call. Unfortunately, we don't seem to hear the wake-up calls when it is required. When do we hear it? That's the question. Because there is a tendency amongst us to hit the snooze button, to delay a bit later, a bit further later. This is what is happening with the administration of JJ Act 2015. Despite the blaring sound of the wake-up calls, we have not yet kick-started. Now, I was told one day by Honorable Justice Ashwini Kumar Singh that he made a visit to some of the children's homes, and he found that with petty offences, they were languishing in such homes for about a year or so. Now, this is no administration of the JJ Act. Now, therefore, this topic has been chosen as one of the most important topics in the administration of Juvenile Justice Act. Now, there is a reason behind complacency. Why we have become complacent? In the first instance, there is a false sense of having achieved everything with the legislation, with the infrastructure, with the children's homes, with the observation homes, everything in place. And therefore, we presume that the act is being administered properly. The second is our own human tendency to put our fingers on the snooze button as soon as we wake up. Now, this is hit the snooze button syndrome. Now, the temptation to put off has to be avoided. It has to be prevented. It has to be shunned. Now, to begin with the topic, I hate to speak statistics because more often than not, it's exaggerated. But the fact of the matter is that the UNICEF has estimated that 153 million of children globally have lost one or both of their parents. 43 million out of them live in South Asia alone, which includes India. Besides orphans, there are a substantial number of children who have been ousted from the family protective net, and they have got institutionalized as abandoned, abused, runaway children, or children in conflict with law. Let me remind you that children in conflict with law and children who are in need of care and protection are our primary focus today. I have used the expression institutionalization of children. What does it mean in the context of JJ Act? Now, only when we know what is institutionalization, we would know what is the importance of deinstitutionalization, which is one of the major components of today's topic. Now, it refers to different kinds of residential facilities where boys and girls spend their lives. Examples are children's homes, care homes, juvenile detention facilities, prisons, orphanages, reform schools, schools for physically and mentally retarded children. Any child who stays in any one of these institutions, which is other than the home, they are said to be institutionalized. This is the meaning of the expression institutionalized, which we must keep in mind. Children who are away from home, presumably for their betterment, and where they could be protected. Now, this gives rise to a very, very paradoxical situation. If a child in conflict with law or in need of care and protection is not institutionalized, he is allowed to remain the runaway child that he is. He is allowed to remain on the streets the way he is. Then perhaps there is every likelihood of his being exploited and marginalized. The inhuman and violent life conditions which he would face otherwise would turn him into a law offender, many a times drug abusers, or perhaps exploiters themselves. Now, this is when he is not put in an institution. We are talking about deinstitutionalization. How to see that? How to perceive that? If they are institutionalized, the reason is that there is no guarantee that they shall not be exploited or they shall not be provided, they would be provided the fullest opportunity of developing themselves. Now, there has to be a balance, and where is this balance? Now, this is the question which we are called upon, for which we have gathered to ponder over. There has been, I must tell you, a very interesting and sharp development, I may say so, in the line of thinking globally. The development of human rights principles at the international level has directly resulted in decrease in the numbers of institutions, because there has been a phenomenal change in the models of children's institutions today. The debate for and against the institutionalization is not new. It has begun since 1950s. The concept of institutionalization, if I take you back to some part of the history, it first began with Catholic churches. The churches in Italy, they started making constructions where they could house runaway children, destitutes. This exercise, this kind of a feeling spread over the other churches of the world. Sometimes later, with the growth of institutionalization and development of capitalism, children were made to work in factories, and there was a capitalist model where everything was to be extracted from the human force, which gave rise to the typical bourgeoisie concept. I mean, I'm taking some concepts from history and sociology. The bourgeoisie concept of rescuing a child. Now, these actually offset the capitalist economic model over the process of time, and a rescue model, a new model emerged, which was looked at by world at large, by people who were entrusted with the dominion of administering laws in favor of children. Reports from various countries kept pouring in, and it depicted a picture that children living in institutions are more prone to violence than those living in families. So this was the beginning of the thought that institutionalization as a measure for betterment of child is not the be-all and end-all. I'll tell you the statistics again. The statistics is that the violence in residential institutions are approximately 6 times higher than violence in foster care and family-based care homes. It was also found that boys and girls in these institutions are sexually abused, and many a times they also sexually abused others on whom they could exercise their physical control. The staff and the officials responsible for managing those institutions also many a times became predators, perpetrators of offense. This was not very uncommon. If anybody has been a hostler, you would know that a boy with larger frame would bully his younger friend in the school hostel. You've seen that. And this was one of the ideas where boys of different age groups were segregated. There was another category of children, those who were prone to committing self-harm, because there was no greater control over their activities over the day. So these were boys or girls who had suffered some kind of trauma in their lives. So they were more prone to inflicting harm on themselves. A report of the United Nations disclosed that the impact of institutionalization on child goes beyond the immediate exposure to violence. Now, it is not only violence, but it impacts them in a long way, in a measure which would be irredeemable, irrevocable. Long-term effects are psychological damage. These people turn out to be men who would see the world with a cock eye. They would feel that they have faced the worst of the world. They would not give anything better to the society. This kind of psychological damage, suicidal tendencies, criminal proclivities, they actually disturbed the human being when they became adult with a difficult childhood. See, these findings became very common. And once a generality of feeling regarding this was perceived about the evil effects of institutionalization, that an idea gained ground that children should not be taken away from their communities, from their schools, from their homes, unless all the options have been explored and exhausted. If a child has committed a petty offense, let him not be sent to the children's home. Let him be kept under the guardianship of somebody, if not parents, who would have a complete control over him, who would give homilies to the child, and the child would listen to those homilies. This idea gained ground that don't let him be in large institutions which are managed by law, which are managed by state, which are managed by staff who are almost impersonal to the needs of the child. Now, this was the step towards deinstitutionalization. Now, this concept started gaining momentum. There was a political support worldwide, and because of such political support in different nations, several legislations were enacted which were either directed towards proper management of those institutions, or now this was a very good orientation. Proper management of institutions was one part of looking at the idea of deinstitutionalization, but the legislation also geared towards investment in families which could be entrusted with the dominion of children in need of care and protection. Now, one result of this was establishment of SOS Children's Villages, if you have heard of it. It is an international non-governmental organization. World over, they have centers. In India, across 21 states, across around 22 states now, they have 33 centers. They provide that kind of an atmosphere which a child would find at home. It would not be a complete home, but the staff who is chosen is sensitized about the need for providing a homely atmosphere to these children, runaway children, children who have offended certain laws, children who are in need of care and protection, orphans, etc. I need not tell you about the United Nations conventions and Child Rights Convention and Beijing rules. They are too common to be repeated, because these came into being in right since 1989. India was a signatory to one of these instruments in 1991. What was important in these international instruments was that the member states were mandated to frame laws for the benefit of child with a special orientation towards deinstitutionalization. The mandate was that a child should remain at home, at school, in his own community, in his own setting. This required the family situation of a child to be investigated. Now, this is very important. Herein lies the political will, the will of the state, the will of the administrator. The family situation of a child is required to be investigated. Placement of a child in residential facility only in his or best interest. Guidelines were issued in this regard. Everywhere, the buzzword was the institutionalization has to be a mode of last resort. Now, these guidelines, I must tell you, they echo the necessity and suitability principle. These concepts one must understand, because that would help us understand the parameters for grant of bail also. The necessity and suitability principle has to be understood in its context. Now, what means necessity? The necessity principle involves preventing a situation which forces a child to be kept in alternative care. Now, that situation has to be prevented. Very often, families with lesser income, they want their children to be maintained at a state cost because they can't afford. Very often, the children with disabilities are so unwelcome in their families that they run away. They are not taken care of in the family, they go away. Children not born out of the wedlock, children of single mothers, children who have committed petty offenses and have been taken charge of by the law enforcers, sent to juvenile homes, place of safety. Earlier it used to be called remand homes, which is an expression which is prohibited. These days it cannot be used. I once used such expression, and Brother Ashwini Kumar Singh told me that you are not matured enough and sensitized enough to deal with children's law, because you are using the expression remand home, you are using the expression accused. But that was only because it was inadvertent. It was a slip of tongue. So the necessity principle also involved a robust gatekeeping mechanism. As a gatekeeper stands at the gate and stops unwelcome people inside the institution, so a robust gatekeeping would ensure that children who could be kept in their homes be allowed to remain in their homes and not taken to these large institutions where they don't get an opportunity of their fullest development. So this is the necessity principle. This involves a complete supervision of the situation, an understanding of why the child is not being treated properly at home, why a child has resorted to recidivism, going back to the criminal proclivity. Now, if no option is available, which is best suited for the child, then only he should be kept in an institution. The suitability principle is that every child is different and is required to be treated differently. Now, if you think that your job is over by putting a child in an institution where he would be fed, perhaps everybody is mistaken. Now, every child needs a different kind of care plan. Somebody is more sensitive. Somebody wants to pursue his studies. Somebody is not at all concerned and happy with 2 square meals a day. He needs that affectionate hand behind his back. Now, every child is different, that we must understand. And the moment we understand this, we would know and appreciate the effort of Indian legislation in this regard, where alternative care has been suggested instead of keeping a child in close confines of which home is that? Child's home, children's home, place of safety, etc. This includes the best interest of child. The expression best interest of child is not an empty expression. It includes the right to protection and a chance for harmonious development. Now, what is this protection? Protection means right to life, right to living, and right of survival. 3 aspects: right to life, right to living, and right to survival. This includes in it a cover, a protection, a protective umbrella from any form of hardship, abuse, or neglect. It could be either physical, psychological, mental, or emotional. Side by side, it also includes harmonious development, which means a situation to be provided to a child where he can have a reasonable standard of life and living, which is necessary for his overall growth and healthy development. Now, if this is the best interest of child, you tell me where a child needs to be placed. Large institutions where he is fed at the cost of the state, or a family which is given some assistance for maintaining their children because they can't maintain them. Now, this idea actually weighed with the legislature world over, and legislation in this regard was enacted. Best interest of child, the expression has been defined in JJ Act. Now, before I go to the Act and relevant provisions which inherit in it the general principles to be followed, especially the best interest of child, including efforts at deinstitutionalization, a word why this law has come into existence. In the social context, apart from the law, I'm now referring to the global social context. People with difficult childhoods, troubled childhoods, criminal background, runaway children, they have made it rather big in the family. They have greatly contributed to the society. They only required during those troubled times a direction, a space, some kind of guidance, so that they did not feel that they are useless adjuncts of society. They are not welcome. Now, once that was given to them, they have flowered. Instances are abound. This is what I have said is not some kind of an altruistic rhetoric, but history has proved it that with little direction, people with very, very troubled childhood, they have made it rather big. They have been the leaders in their fields. And this is why the importance of administration of the Child Act in a proper manner. Do I need repeat that children are the future of the nation and they cannot be allowed to be wasted? Not me, everybody, every great political leader who has had the occasion to lead nations, John F. Kennedy and others, all authors, writers who have turned their gaze towards children's rights, they say that children are the national wealth and therefore every effort should be made to preserve that wealth. These are not empty and wishful thinking. I will give you some examples. Generally speaking about people with troubled childhood would not hit the alarm bell, would not ring in the minds of people. I must give you, this is for the attendees, I must give you examples also. You have heard of Carlos Acosta. I hope you have. If you have seen television and if you are interested in ballet, dance or any form of dance, you have heard of Carlos Acosta. He was a Cuban national, 11th child of a poor truck driver. The mother was absolutely ill. He was so poor that his neighbors put him in a government school teaching dance because he could be fed at least once a day. Today, he is one of the greatest performers of ballet dance. He is the leader. Another example I'll give you. Ashwin Willems. He was a small-time drug dealer in South Africa. Most of his friends were either dead or in jail. He himself was shot twice. But somehow or the other, with some direction from a distant neighbor who was his relative also, he discovered rugby, which turned his life around. Today, he is known as a winger of matchless speed, agility, and power. He is a role model for today's rugby players of the world. Malala Yousafzai, I need not talk about her, the youngest recipient of Nobel Prize. She is often compared to the Holocaust diarist Anne Frank. She has done so much for the rights of children. She has been a leader at this age. I would with great enthusiasm refer to the name of Oprah Winfrey. I bet nobody can say that he has not seen Oprah Winfrey. She has revolutionized American television. Let me tell you, she was sexually abused by her relatives when she was 13 years old. She had to run away from her house. She could somehow or the other settle with her estranged father, who gave her some direction. And today she has financial worth of $4.3 billion. She is one of the richest Afro-American person. She is a great philanthropist also gay rights. She has done lots, so on and so forth. Charlie Chaplin, he also had a troubled background. He used to bartend to earn his livelihood. Somebody told him that you can do great, you can act great with the Trump character in silent movies. He started that, and he was liked by the masses. The list is endless. But only recently, while I was making some preparation for this talk, I could lay my hands upon this book by Greta Thunberg. I am showing this if it is visible on the screen. Greta Thunberg. She is born in 2003 only. She is younger to most of our children. She has written a book, No One is Too Small to Make a Difference. Why I am taking her reference is that in 2018, when she was only 15 years of age, she decided not to go to school one day. She started a strike for the climate and for the planet. outside the Swedish parliament. Her actions have ended a sparking debate world over for climate crisis. She has inspired millions. And why I am saying so? Not only because of her age. She has a disability. She suffers from Asperger's. Asperger's is a disease which makes one ID fixated to a topic. It's a violent condition where a person is fixed to one particular thing to a fault. Now she says when somebody asks her that you at this age is suffering from Asperger's, you are not going to school, what do you have to say about this? She says it's a gift from the God. I can see things in black and white. Now she can't read or write, but whatever she speaks, that's collected, and this is a collection. No one is too small to make a difference. We must understand we are talking about children. Now I have taken these names of the personalities to only let you know that a person with troubled childhood does not necessarily become a criminal. The society ought not to discard them, rather facilitate their growth. They can be assets to the society and they can be future leaders of the world. Slightly away from this, they are the players of the world. They are the leaders of the world in their field. Now look at the efforts of people globally. Look at the efforts that they have made and whether it has bore fruit. Now, activists and authors, I would also commend them for the tremendous work they have done. Now, organizing a webinar for a proper implementation of the Act is no less. Now, I'll tell you, you fall, I mean, the JJ Monitoring Committee would fall in line with these authors and activists who have done a lot, and I will take the names of you. Erik Erikson. Most of us hear this concept of identity crisis. The word is used in rather negative sense, that somebody having identity crisis is behaving behaving improperly. Now, this identity crisis concept was coined by Erik Erikson. Now, he has written some biographies about big authors, big leaders. Martin Luther is one such personality. And he says that as a child, Martin Luther stood up to his father to demand something. And probably this seed in him developed to the fullest when he stood up against the church. He stood on the pulpit and started speaking about the reforms of church. So this idea which had occurred to him as a child, it formed into an identity crisis which led him to become the leader one day. Now this was also because of the fact that writers and activists chose this topic to speak upon, to deliberate upon. Then there is an Indian example, Kailash Satyarthi. You have heard of him. He has done so much of work on child rights. Craig Kielbarker. This man is the founder of the movement called Me to We, not Me Too, Me to We. So this is also a worldwide movement which has gained ground. Muzoon Al-Melhan, she is known as Malala of Syria. Molly Melching, Memory Banda, Iqbal Masih, that boy you have seen him on television. He died. He was working for dead slave children in Pakistan. Monira Rahman, she actually worked for prisoners' children in Nepal jail. Indra Ramnagar, Molly Melching there, female genital cutting, forced marriages. These are the issues which were taken up by these activists with true spirit, and it did bear fruit. Now, here again the list is endless, but I would refer to a special class of mothers, Dunga mothers, if you have not heard of them. These Dunga mothers, they are also called mothers of Saint Rita. They are less educated, less privileged women of South Africa. And they have struggled for helping children living in villages of Kenya who have lost their parents to AIDS. Nobody would have thought of them. They were not welcome in any family, even in their relatives' family. These Dunga mothers They are not educated. They can't even feed themselves. But they have chosen to be the vanguard for helping these people, for helping these children who are in need of care and protection. They are not runaway child. They are not offenders. They are not in conflict with law. But they are the persons, they are children who are in need of care and protection. Now, let me get back to the Indian context now. Enough of the world context. Let me tell you how this act came into existence. I think I'm quite in time, Mr. Moderator, sir. Do I have some more time so that I speak about the parameters of bail? I don't find the moderator. Well, there are two cases which are important and which need to be stated. Sheila Barse versus Union of India. Citation, I'm not speaking because the case is too well known. It can be found on any platform. There was an observation of the Supreme Court that it would be desirable if the central government initiates a parliamentary legislation on the subject of child rights so that there is complete uniformity in regard to various provisions relating to women. This observation was in the global context and in the context of there not being a pan-India law to govern children. This bore fruit. The observation was taken very seriously, and Juvenile Justice Act 1986, Juvenile Care and Protection Act 2000 came into existence. The age of juvenility was fixed. Boys and girls who were of 18 years and below were treated as juvenile. Then everything was going fine. At least apparently, children were getting the privileges which they should have and which they deserve. But something happened in the year 2012. The horrible incident, Nirbhaya. Nirbhaya was brutally raped and murdered. A very enlightening picture on this you would find on Netflix. This called Delhi Crimes. In fact, I have gone through the material because for some reason or the other, I had to deal with one aspect of the matter while sitting in different jurisdiction, and I had the research material. And the movie which has been made, it's a short movie which has been made. It has taken into account various facts which are not known to people. But anyway, now, one of the perpetrators of the crime was a 17-and-a-half-year-old boy. He was about to get that privilege under the Juvenile Act. Now, this led the civil society to react violently. They started debating that, well, they are getting protection. They don't need to. They are not children who could be given toys to play with. They want guns. They are criminals. Salil Bali versus Union of India and Subramanian Swamy and others versus a member Juvenile Justice Board. These are the two cases where the jurisdiction of the Supreme Court was invoked to take a relook at the juvenile laws, especially with respect to the age of juvenility. The moderator has come. Sir, do I have some time, no?
Please, Brother Asutosh, you please go ahead. In fact,
Right.
I have also consumed a lot of your time. So please go ahead, Brother Asutosh.
All right. So in these two cases, the Supreme Court rebuffed the challenge. They said that this decision is to be left to the legislature, and this is not the arena where the courts could interfere. And then came the JJ Act of 2015, which made a departure from the earlier laws in many respects. Now, deinstitutionalization was inherent in it. No jail, but a care plan was again inherent in it. A special reference of the Act, other provisions, Honorable Justice Ashwini Kumar Singh and my dear brother Rajiv Ranjan Prasad would deal with it. I am not going to make any inroads in their topics, but a special reference be made to Chapter 2 of the Act, which deals with the general principles of care and protection while administering the Act. Section 3 talks about certain principles. The general principles which have to be followed are presumption of innocence of child, dignity and worth of a child, A child has to be heard and he has to be given an opportunity of participating in all the processes which is affecting his interest, be it judicial proceedings. The principle of best interest of child, which would allow full development of his potential. The fifth guideline, which is very important and I need to re-emphasize, this is the principle of family responsibility. Now, I've been asked to speak on deinstitutionalization and synchronization. Now, this is one of the principles which says, without referring to the word deinstitutionalization, the orientation is on the emphasis. The emphasis and orientation is on the family. Family responsibility. The primary responsibility of care and nurture and protection of child, shall that be of biological family or adoptive or foster parents, as the case may be. Now, this is one of the guiding principles, a lodestar in the process of implementation of the Act. The concept of deinstitutionalization is inherent in this scheme. Safety of child, so that he is not subjected to any harm, abuse, or maltreatment. This also is an indicator towards the orientation of deinstitutionalization. The framers of the law were aware of the inherent dangers of large and closed institutions, and therefore the best interest of child, they thought, would include measures towards safety while in contact with care and protection system. Now, positive measures for mobilizing family and community for the purpose of promoting well-being and facilitating identity of a child are also principles which have been enumerated. Now, this therefore requires to fall back upon the suitability and necessity principle which I have just spoken. Only when intervention is required, let us remember, only when intervention is required as administrators of, while administering the law, we must understand that intervention is necessary. Intervention has to be resorted only when all other ways and means have failed. And you can know that only when you have explored those ways. Unless you find out, you just can't make a statement that it is the best interest of child to be kept in an observation home or a place of safety. Now you have to explore. What does the child want? What is his father? How would he be fed? What is his dispensation? Now these are the principles. Now this principle led to formulation of other designs in the Act. Other principles I am not referring to. These are global principles in the Convention of Child Rights, Beijing principles, etc., non-waiver of rights, equality and non-discrimination, privacy, confidentiality, non-stigmatization. Well, those are very important guidelines, but for the moment we are concerned with deinstitutionalization and parameters for grant of bail. Therefore, I am keeping it at a back burner. The administration of law would not keep it on the back burner. But for the talk today, I am not referring to those principles. Institutionalization as a measure of last resort is specifically mentioned in Section 3, Chapter 2 of the Act. It specifies that a child shall be placed in institutional care as a step of last resort, and that also after making reasonable inquiry. This is synonymous with the principle of repatriation, restoration. Now, everything is linked with the other concept. Now, if biological family is given the responsibility, if there is an investigative role with respect to the family, if the child's dispensation has to be looked at, and his best interest has been defined, and all this is geared towards restoration and repatriation. Am I wrong if I say that the process of deinstitutionalization, the concept of deinstitutionalization is inherent in the Act? We need not bring it from outside. It says so, it declares so, it mandates so. Now, if these principles, now enough for the deinstitutionalization, the benefits of deinstitutionalization and harms of institutionalization. If these principles are kept in mind by the Juvenile Justice Board, Children's Court, Sessions Court, we ourselves in the High Court, If we keep these principles in the back of our head while administering this law, the child rights shall be well subserved. After having said this, I think I have very little to say on the parameters for grant of bail. Section 12 of the Act, but shortly because I have to talk about synchronization. I think I have made some stress that every concept is interlinked. So Section 12 of the Act provides that when any child in conflict with law who has committed a bailable or non-bailable offence is apprehended or detained by the police, or he appears or brought before the Juvenile Justice Board, such person, notwithstanding anything contained in CRPC or in any other law, shall be released on bail with or without surety. One must keep in mind, with or without surety. This decision has to be of the board. This decision has to be of the police officer. A police officer also can release him on bail, or be placed under the supervision of a probation officer or under the care of a fit person. Now, probation officers and fit persons have been defined under the Act. A juvenile but shall not be released on bail. Now, here comes the parameters, what we have to keep in mind, what the administrators of the Act have to keep in mind. A juvenile shall not be released on bail if there appears reasonable grounds for believing that his release is likely to bring him into association with any known criminal, or expose him to moral, physical, and psychological danger, or defeat the ends of justice. So there are three exceptions which have been enumerated. If the release of a child is likely to bring him into association with any known criminal, or expose him to moral, physical, and psychological danger, or it defeats the end of justice. These are the three exceptions only under which bail would be refused. Now, what shall be done thereafter has also been specified in Section 12. If the boy is not released, boy or girl, I mean any offender, any child in conflict with law, if he is not released on bail by the officer in charge of the police station, such officer shall keep the child in observation home in such manner as may be prescribed until he is brought before the board. If the child is not released by the board shall make an order sending him to an observation home or to a place of safety, as the case may be, for such period during the pendency of inquiry regarding the child. Now, another condition which has been provided, which would tell you another parameter. Now, he has not to be kept in any one of these homes and institutions. Now, if a child in conflict with law is unable to fulfill the conditions of the bail order within 7 days of such bail order, he shall be produced before the board for modification of those conditions. Now, many a times I have found, sitting in the revisional jurisdiction and also in the appellate jurisdiction, that the conditions which have been imposed and which a child or his family is not able to fulfill, they come for a modification before this court. That is not required. Within 7 days, if the order has not been given effect to, it goes before the Juvenile Justice Board for modification. The board is the first institution which looks after the well-being of a child in conflict with law. So a plain reading of Section 12 makes it very obvious that the three conditions only which I have said, any further repetition would make it boring. Three conditions: if it exposes him to moral and psychological danger, likely to put him in contact with criminals, and ends of justice. Other grounds like nature and gravity of offence, it is not at all relevant while deciding an application for grant of bail. So grant of bail is a rule, exception only three which have been stated. And these grounds are, mind you, exhaustive. An application for bail cannot be rejected on other grounds. The approach of the juvenile board or of the children's court or of the High Court in revisional or appellate jurisdiction has to be different. It cannot be in tune with what we do while sitting in jurisdiction dealing with 437, 438 and 439 of the CRPC. Absolutely different orientation. The legislature has purposely given an overriding effect to the provisions of the Juvenile Justice Act by clearly mentioning that provision of Section 12 would operate notwithstanding anything contained in any act whatsoever. Now, in this context, I would briefly refer, if the report of a probation officer assumes immense importance because it contains social investigation report of the child in conflict with law, and this gives an insight to the board or to the children's court as to what should be done with the child. Individual child needs individualized care. Every child is unique in himself. The social investigation report is therefore the basic material before the court, apart from the other attendant circumstances. Now, the probation officer or the child welfare officer under the Act are directed that they will be, immediately after the apprehension of these, after they are apprehended, the probation officer and child welfare officer are entrusted with the task of preparation and submission of the report within 2 weeks, and they are required to submit it to the board. Such report will contain information regarding the antecedent, family background of the child, and what kind of assistance could be given to him, whether de-addiction, is going to school, any reformatory school. So these are the material before the children's court, before the Juvenile Justice Board, to deal with juvenile in conflict with law. Now, again, I'm avoiding any discussion on section 14, 15, 18, and 19 of the Act, which are also important so far as the concepts are concerned. But I believe Honorable Justice Ashwini Kumar Singh would be talking about navigation of these principles, navigation of these provisions. So it would be a repetition. I'm leaving it, and I'm also running short of time. I will only refer to one of the cases authored by Justice Singh, Lalu Kumar, alias Lalu Babu, alias Lalu. Now, this I'm sure every speaker would be referring to because it's almost a compendium of all the concepts. It includes everything in itself. Now, I would only refer to it for two questions which were framed as ancillary questions by a division bench headed by Justice Singh. Whether the same principles which apply to a board, Juvenile Justice Board I mean, in dealing with bail applications, whether they apply to children's court also. The answer was in clear terms in affirmative, yes. There is no other consideration except what has been stated in section 12. Therefore, the judicial opinion over this is absolutely clear that nature and gravity of offense is not to be looked into. At least it should not be the basis for taking a decision regarding any application for bail. Now, in this context, I must tell you, the last of the difficult areas with respect to grant of bail, there has been a note of divergence. Now, judges, some of the judges of different courts have said that two of the exceptions mentioned in section 12 are all right. If the board or the children's court feels that release is likely to expose him to criminal ways, likely to endanger his sociological mold, all right. But the third exception, if it defeats the ends of justice, what does that mean? Does that exception require to be read adjustem generis with the other two concepts, with the other two exceptions, or it has to be read distinctly and separately? A court in Allahabad, a very learned judgment, of course, it says, yes, the third of the exception, namely, release shall not be ordered if it defeats the ends of justice. It should not be read adjustem generis. It has to be read distinctly. Now, I'll briefly refer to what had happened in that case. Raju alias Ashish versus State of Uttar Pradesh is the case. Citation you will get anywhere. Press it on any platform, you will find from Allahabad High Court. There, the offender had eve-teased the daughter of the informant. The son of the informant protested. This child offender, he along with his associate, pushed the daughter of the informant and his son into a nearby well, water body, well. The passers-by, on hearing the commotion, tried to rescue both the children. They could not. Both the children died. The offender was brought before the Juvenile Justice Board. Juvenile Justice Board refused to release him on bail. Children's Court, that also refused to release him on bail. The matter came to High Court in revision, not in appeal. It came in revision. Justice Singh will refer to various provisions. Now, the court said that, look here, it is a beneficent provision meant for betterment of children, but it cannot be a safe haven for this person who has broken law with such depravity. Ends of justice is something which is very important. If benefit has to be given to a child offender, something has to be seen about the accuser also. And when a specific plea was raised with respect to reading that exception as adjustum generis with the other two exceptions, the court says, no, not at all. If this is read adjustum generis with other two exceptions, perhaps there would be a failure of justice delivery mechanism, and the bail was rejected. Well, if I were to decide that, I may not have released the person on bail, but not on the ground that the offense was very depraved. Offense was very serious, but only after taking into consideration the social background, the situation why that offense was committed, whether it would be in the best interest of that child to go outside the closed walls of the observation home or the juvenile home, or it would be better for him to be kept under the supervision of law enforcing agencies. The depravity of the crime or the seriousness of the crime would not have been the basis of discussion. Now, this has been very well echoed by one of the judges of Bombay High Court, my friend, Brother Damshesh Adri Naidu. This case, I would failing in my duty if I don't refer to that case. This is Muhammad Huzaifa Zaved Ahmed versus State of Maharashtra. This was a case where a 17.5-year-old boy had brutally killed a 3.5-year-old child. There was another associate of this juvenile offender who was younger to him. He was only 16.5 years, only 1 year younger. So he was also found to be part of the conspiracy. He helped the older juvenile into screening the offense and escaping the police net. He helped him escape the police custody. The older of the juvenile, 17.5 years old, was declared to be fit to be tried as an adult. The younger juvenile, 16.5 years, the board thought that he should be tried as a juvenile. The difference was only of 1 year. Now, 2 appeals came to be filed before the Sessions Court. One by the government against the decision of the board to treat the younger juvenile as a juvenile and not as an adult. The other by the older juvenile, treating him, holding him to be fit to be tried as an adult. Now, both the appeals were dismissed. The challenge came before the Bombay High Court. One was an appeal against the order. One was an appeal by the just a minute. Against the orders passed by the Sessions Court, the father of the victim. Now, this time the father of the victim preferred an appeal. The older of the juvenile had also filed a writ petition where the father of the juvenile joined as an intervener. This was a wrong forum exercised by the parties. Notwithstanding that, the High Court took a look at the entire gamut of the Act, the principles behind implementation of the Act, and the High Court dismissed both the petitions, saying that dismissed one petition and approved of the order whereby the younger juvenile was to be tried as a juvenile, and also that petition where the older juvenile was declared to be fit enough to be tried as an adult. The High Court was of the feeling that both of them should be tried as juvenile. Now, while doing so, very interesting observations were made by the Honorable Judge. Now, he went through the entire research work, internationally acclaimed research work, especially that of Mr. Aaron Kopchik of University of Delaware, where there was something which made a person juvenile or adult beyond the concept of the numerical, and relied upon the medical health and other attendant factors, and found that both of them required to be tried as juvenile. The most interesting observation which Justice Naidu made was this: let us not forget, I'm quoting him, let us not forget that public opinion is versatile. Don't be afraid of it. One day it weeps for the victims and cries vengeance, sometimes more than the victims themselves want. The next day it decries the prison as a school of crime. So therefore, don't brace for these public opinion. He conquers and reckons that merely on the premise that offense is heinous and it lends to societal volatility of indignation, one should not brace for juvenile recidivism. Retributive approach needs to be shunned totally. It is all restorative approach and not retributive approach. And then he again says, condemned, any juvenile is going to be a mere number in a prison for lifetime. Reformed, he may redeem himself and may become a value addition to the society. Let no child be condemned. Now that's all for the concepts. I would end my talk with what N.K. Jemisin, an American science fiction and fantasy writer who has also worked as a counseling psychologist, has said. There are no greater groups of warriors than a society protecting their children. Children, and John F. Kennedy, again, I would repeat, children are the world's most valuable resources and its best hope for the future. Well, thank you, and over to the moderator.
Thank you very much, Brother Ashutosh Kumar. I noticed exceptional synchronization of your heart, mind, and speech while dealing with this topic of synchronization of the concept of deinstitutionalization in the best interest of child. Brother Asutosh has opined that concept of deinstitutionalization is inherent in the JJ Act. He has reminded the stakeholders to make themselves able to hear the wake-up call, overcome complacency, and with a special reference to section 12 of the Act and 3 exceptions, he has opined that there is a requirement of robust gatekeeping. The most significant takeaway for the participants on the subject, on the basis of what has been said by Justice Asutosh Kumar, is that third exception of section 12 of the Act is to be read with 2 other exceptions of the Act and not independent of the 2 exceptions. His address has been an education for me, and it must have been learning for all the participants and attendees. I thank him for the illuminating address. Now, can I request Brother Justice Rajiv Ranjan Prasad to address us on the second topic?
Thank you, sir. Honorable the Chief Justice, Mr. Justice Sanjay Karol, Honorable Mr. Justice Ashwani Kumar Singh, Chairman Juvenile Justice Monitoring Committee, Patna High Court. Honorable Mr. Justice Ehsanuddin Amanullah, Member. Honorable Mr. Justice Secretariat Singh, who is the moderator of this seminar. Honorable Mr. Justice Arvind Srivastava, my esteemed brother, Honorable Justice Ashutosh Kumar, and all other honorable sisters and brothers, retired as well as sitting from Patna High Court, honorable judges from any other honorable court, Sri Atul Prasad, the Additional Chief Secretary, Department of Social Welfare, Government of Bihar, Sri Vinay Kumar, ADD Weaker Sections, Sri Raj Kumar, Director Social Welfare, other state government officials, members of the Registry of the High Court, and Juvenile Justice Secretariat. The learned district and session judges, the principal magistrates, learned advocates, social worker members, probation officers, dignitaries, delegates, print as well as electronic media reporters, both from audio and visual, and all other participants. Ladies and gentlemen who have joined this webinar today, greetings to all of you. In our pursuit of sensitizing all the stakeholders and bodies responsible to ensure implementation of the aims and objects of the Juvenile Justice, Care and Protection of Children Act 2015, which I will refer here in after as JJ Act 2015, we have assembled today through this virtual mode during the pandemic period. The topic of this session is, quote, creating a child-friendly atmosphere and protective environment during inquiry and trial under the Juvenile Justice Act. Issues and challenges, unquote. While talking on this topic at the outset, we need to ask a question to ourselves as to why at all a concept of child-friendly atmosphere and protective environment has been brought into existence under the JJ Act 2015. The answer is not difficult. The background in which, after the Nirvaya's case, the JJ Act 2015 has been brought into existence has been eloquently dealt with in the case of Lalu Kumar versus State of Bihar, reported in 2019 4 PLJR 833, authored by none else but the Honorable Chairman of the Juvenile Justice Monitoring Committee of this court, Honorable Mr. Justice Ashwani Kumar Singh, sitting with Honorable Mr. Justice Virendra Kumar. Brother Ashutosh has briefly talked about that judgment, and I need not go into detail at this stage. The concept of double safety valve operating at the stage of preliminary assessment by the board and again under Section 19 before the Children Act to protect the interest of a child has been well explained in the said judgment. Thus, without going into much detail behind the legislative history of the JJ Act 2015, it may be stated that a child has always been treated as a national asset. Under Section 2, Clause 35, a child below the age of 18 years has been defined as a juvenile. Section 2, Clause 13 defines a child who is alleged or found to have committed an offence and who has not completed 18 years of age on the date of commission of such offence. They are known as child in conflict with law. Clause 14 of Section 2 defines child in need of protection and care, and there are long list of illustrations under various clauses, sub-clauses of Clause 14. If any of the child fall in any of those categories, he will be covered there as a child in need of protection and care. I quote a famous saying by Dr. Seuss, an American children author. He said, quote, a person is a person no matter how small. In the case of Sheila Varsa 2, reported in 1986 scale, volume 2, page 230, which dealt with abandoned or destitute children, the Honorable Supreme Court of India, having gone through the national policy for the welfare of the children, took note of the relevant part thereof. Quote, the nation's children are a supremely important asset. Their nurture and solicitude are our responsibility. Children program should find a prominent part in our national plans for the development of human resources, so that our children grow up to become robust citizens, physically fit, mentally alert, and morally healthy, endowed with the skill and motivations needed by society. Equal opportunities for development to all children during the period of growth should be our aim, for this would serve our larger purpose of reducing inequality and ensuring social justice. Unquote. The Honorable Supreme Court took a view in the case of Sila Varsa too, that the state is duty bound to look after the child with a view to ensure full development of the personality, and that is why the statutes dealing with the children provide that a child shall not be kept in a jail. It was also directed that on no account should children be kept in jail, and if a state government does not have sufficient accommodation in its remand home or observation home for children, they should be released on bail instead of being subjected to incarceration in jail. If we believe Nelson Mandela, then it would be important to know what Nelson Mandela had to say about the children. Nelson Mandela said, quote, there can be no keener revelation of a society's soul than the way in which it treats its children. Unquote. Him Ginnott, a child psychologist, psychotherapist, and parent educator, said, quote, children are like wet cement. Whatever falls on them makes impressions. Unquote. The treatment of a juvenile in a friendly atmosphere is a duty imposed upon the state and all the stakeholders. The inquiries and trials involving a juvenile in conflict with law are required to be taken up with some compassion towards them, and juveniles in conflict with law are entitled to the presumption of innocence. The JJ Act 2015 requires the conduct of inquiry and trial of a juvenile in conflict with law with utmost degree of sensitivity, care, and empathy for the victim. The juveniles are not to be traumatized by the court proceedings, and it is the duty of the institution dealing with the juveniles at all levels to create a friendly atmosphere and environment to the juveniles. Now, coming to the scheme of the JJ Act 2015, the opening statement, which is also called preamble of the Act, reads, quote, an act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, by adopting a child-friendly approach in the adjudication and disposal of matters in the best interest of children, and for their rehabilitation through processes provided, and institutions and bodies established herein under and for matters connected therewith or incidental thereto. The JJ Act 2015 acknowledges that our Constitution confers powers and imposes duties under Clause 3 of Article 15, Clause E and F of Article 39, Article 45, and Article 47 on the state to ensure that all the needs of children are met and that their basic human rights are fully protected. The Government of India has agreed on the 11th December 1992 to the Convention on the Rights of Child, adopted by the General Assembly of United Nations, which has prescribed set of standards to be adhered to by all state parties in securing the best interest of the child. There are various other related international instruments which prescribe standards on the rights of the child, such as United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985, the United Nations Rules for Protection of Juveniles Deprived of Their Liberty, and the Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption. Thus, all of us should be very clear about the rights of the children and our duties towards them as a state, as a child care institution, a juvenile justice board, children court, or as a constitutional court of law. Apparently, principles of parents patria, that is the state to act as a guardian for the children, has now shifted to the right approach, which respects the constitutional and procedural rights of a child in conflict with law. A juvenile is thus required to be treated in a manner consistent with their dignity and self-respect. The JJ Act 2015 strengthens the protective approach towards children in conflict with law, as well as children in need of care and protection. The scheme of the Act suggests that a child in conflict with law has to be segregated according to age, gender, physical, and his mental status. And the nature of offence committed by the child in conflict with law would also be a factor to be considered for purpose of segregation. The Act envisages to create three categories of violations. A petty offence has been defined under clause 45 of section 2, which includes the offences for which maximum punishment under the Indian Penal Code or any other law for the time in force is imprisonment up to 3 years. A serious offence is defined under clause 54 of section 22, section 2, which includes the offences for which the punishment under the Indian Penal Code or any other law for the time being in force is imprisonment between 3 to 7 years. And a third category is called heinous offences, as defined under section 2, clause 33. A heinous offence includes the offences for which the punishment under the Indian Penal Code or any other law for the time being in force is imprisonment for 7 years or more. Now, having answered as to why a child-friendly atmosphere and protective environment is required, having said that, now the principle of parents patria has shifted to right approach to the children. We will take a view on the concept of child-friendly atmosphere and protective environment as contained in the provisions of the JJ Act 2015. Whenever a child in conflict with law is apprehended by the police, it is the duty of the police in terms of section 10 that such child shall be placed under the charge of the special juvenile police unit or the designated child welfare police officer, who shall produce the child before the board established under section 4 of the Act. The board is headed by a principal magistrate with at least 3 years experience and 2 social workers. Thus, the first step towards a child-friendly atmosphere and protective environment begins right from the stage of his apprehension. The child in conflict with law has to be produced before the board within a period of 24 hours of apprehending him, excluding the time necessary for journey. If we refer to Rule 8 of the Bihar Juvenile Justice Care and Protection of Children Rules 2017, it would further appear that the police is not empowered to lodge a first information report except where heinous offence is alleged to have been committed. Police officer apprehending the child in conflict with law has to just yes. Yes, if we refer to Rule 8 of the Bihar Juvenile Justice Rules 2017, it would further appear that police is not empowered to lodge a first information report except where heinous offence is alleged to have been committed by the child or when such offence alleged to have been committed jointly with adults. In all other matters, the Special Juvenile Police Unit or the Child Welfare Police Officer shall record the information regarding the offence alleged to have been committed by the child in the general daily diary, followed by a social background report of the child in prescribed form, and circumstances under which the child was apprehended, and such report will be forwarded to the court. Under the rule of 2017, the power to apprehend a child shall only be exercised with regard to heinous offences, unless it is in the best interest of the child. For all other cases involving petty and serious offences, and cases where apprehending the child is not necessary in the interest of the child, the police or a special juvenile police unit or child welfare police officer shall forward the information regarding the nature of offence alleged to be committed by the child along with his social background report in the prescribed form to the board and intimate the parents or guardian of the child as to when the child has to be produced for hearing before the board. Police officer apprehending the child in conflict with law has to place him under the charge of the special juvenile police unit or the child welfare police officer. And further, police officer has been specifically restrained under sub rule 3 of rule 8, which says that the police officer apprehending a child alleged to be in conflict with law shall 1. Not send the child to a police lockup and not delay the child being transferred to the child welfare police officer from the nearest police station. The police officer may, under subsection 2 of section 12 of the Act, send the person apprehended to an observation home only for such period till he is produced before the court. That is within 24 hours of his being apprehended and appropriate orders are obtained as per Rule 9 of the rules. 2. Shall not handcuff, chain or otherwise fetter a child and shall not use any coercion or force on the child. 3. Shall inform the child promptly and directly of the charges leveled against him through his parent or guardian, and if a first information report is registered, copy of the same shall be made available to the child or copy of the police report shall be given to the parent or guardian. Shall provide appropriate medical assistance, assistance of interpreter or a special educator or any other assistance which the child may require as the case may be. I mean, these are the rights of the child. Shall not compel the child to confess his guilt, and he shall be interviewed only at the special juvenile police unit or at a child friendly premises or at a child friendly corner in a police station, which does not give the feel of a police station or of being under custodial interrogation. The parent or guardian may be present during the interview of the child by the police. Next, shall not ask the child to sign any statement and shall inform the district legal services authority for providing free legal aid to the child. The child welfare officer shall be in plain clothes and not in uniform. The child welfare police officer shall record the social background of the child and circumstances of apprehending in every case of alleged involvement of the child in an offence in the prescribed form, which shall be forwarded to the board forthwith. When the child is released in a case where apprehending of the child is not warranted, the parents or guardians or a fit person in whose custody the child alleged to be in conflict with law is placed in the best interest of the child shall furnish an undertaking on a non-judicial stamp paper in the prescribed form to ensure their presence on the dates during inquiry and proceedings before the court. Thus, you may easily find that a child-friendly atmosphere and protective environment is in fact the heart and soul of the JJ Act 2015. It starts right from the stage of apprehension of a juvenile in conflict with law. Here, it is important to know that very cautiously the legislatures have used the word apprehended and not the word arrested. The word arrest is stigmatic. Therefore, the said word has been purposely not used in the JJ Act and the rules framed therein. When a child in conflict with law is apprehended but cannot be produced before the board, or even a single member of the board due to child being apprehended during odd hours or distance, child shall be kept by the child welfare officer in the observation home in accordance with Rule 69 capital D of the rules or in a fit facility. Rule 69 capital G provides the procedures to be adopted in the child care institutions. New sets of clothes, beddings, and several other outfits and equipments as per Rule 30 are to be provided. On production of the child before the board has to review the materials such as the social background report of the child, circumstances of apprehending the child, and offence alleged to have been committed by the child. At this stage, the board has to take a view and pass such orders as it may deem fit and proper, including orders under section 17 and 18 of the Act. Then, at first appearance, if it is found that the allegations are unfounded or the child is alleged to be involved in petty offences, the board may dispose of the case by passing appropriate order under those provisions of the Act. The board may also direct the child to be kept in child care institution as appropriate if necessary, pending inquiry as per order in prescribed form. In terms of section 94, board shall determine the age of the child based on appearance and after recording its observations, proceed with the inquiry under section 14 or section 36 without waiting for further confirmation of age. Where the board has any doubt about the age, then they take the process of age determination by seeking evidence. Now, the first kind of evidence is the date of birth certificate from a school, matriculation or equivalent certificate. Then birth certificate of corporation or municipal authority. And in case these are not available, then the board will go for an ossification test. From here the inquiry begins before the board. The board shall notify the date of hearing, but such date should not be fixed later than 15 days of the first summary inquiry. Board may also seek social investigation report from the probation officer, or in case a probation officer is not available, the child welfare officer or social worker concerned through an order. If a child is on bail and he fails to appear before the board, now kindly see the kind of protection granted to a child. If a child is on bail and he fails to appear before the board on the date fixed for hearing and no application is moved for exemption on his behalf, or there is not sufficient reason for granting him exemption, the board shall issue to the child welfare police officer and the person in charge of the police station directions for the protection of the child. If the child welfare police officer fails to produce the child before the board, even after the issuance of the directions for production of the child, the board shall, instead of issuing process under section 82 of the Code of Criminal Procedure 1973, pass such orders as appropriate under section 26 of the Act, which deals with the runaway child in conflict with law. At this stage, any police officer may take charge of a child in conflict with law who has run away from observation home or place of safety or from care of person or institution under whom the child was placed under the Act. Now it is important what I am going to say next. When a runaway child is apprehended and produced before the board will pass appropriate order that the child either to be sent back to the institution or the person from whose custody the child ran away or any other similar place or person. Additional directions with regard to special states may also be passed in the best interest of child. So here also the best interest of the child is to be taken care of. But under subsection 4 of section 26, it is clearly provided that no additional proceedings shall be instituted in respect of such child. This is the protection. No additional proceedings shall be instituted in respect of the runaway child. Now, I am coming to the procedures to be adopted in course of inquiry and how these procedures are to be child friendly and in the nature of a protective environment are well explained in these provisions. In case of heinous offence alleged to have been committed by child who has completed age of 16 years, the child welfare officer shall produce the statement of witnesses recorded by him and other documents prepared during the course of investigation within a period of 1 month from the date of first production of the child before the board, a copy of which shall be given to the child or the parents or guardian of the child. In case of petty or serious offences, final report has to be filed within a period of 2 months from the date of information to the police, except in those cases where it was not reasonably known that the person involved in the offence was a child, in which case extension of time may be granted by the board for filing report. The rule specifically provides under Subrule 7 and Subrule 8 of Rule 10 that when a witness is produced for examination in an inquiry relating to a child alleged to be in conflict with law, the board shall ensure that the inquiry is not conducted in the spirit of a strict adversarial procedure, and it shall use the powers conferred by Section 165 of the Indian Evidence Act so as to interrogate the child and proceed with presumption in favor of the child. So here we can mark this that a juvenile justice board before whom inquiry is going on, the witnesses are not likely to be examined. They should not be examined like a strict adversarial procedure. Here the board has to act invoking the powers under section 165 of the Indian Evidence Act, which in fact confers power on a court of law to ask questions to the witnesses, etc. You can refer to section 165 of the Indian Evidence Act. Here also the board has to presume in favor of the child. This provision is definitely inserted with a view to provide protective environment to the child in conflict with law in course of inquiry. The board has to proceed with the matter with the presumption in favor of the child. At the same time, while examining a child to be conflict in law and recording his statement during inquiry under this section of the Act, the board shall address the child in a child-friendly manner. Here is the statutory recognition of the topic which we are dealing with. It rule says that the board shall address the child in a child-friendly manner in order to put the child at ease and to encourage him to state the facts and circumstances without any fear, not only in respect of the offence which has been alleged against the child, but also in respect of the home and social surroundings and the influence or the offence to which the child might have been subjected to. Even under section 15 of the Act, read with Rule 10 capital A of the Rules 2017, while making preliminary assessment, the child has to be presumed to be innocent unless proved otherwise. After preliminary assessment, if the board passes an order that there is a need for trial of the child as an adult, it shall assign reasons for the same, and a copy of the order shall be provided to the child. The procedure in relation to the Children's Court, as contained in Section 19 of the Act, read with Rule 13 of the Rules of 2017, also prescribed similar provisions as envisaged under Sub-Rule 7 and Sub-Rule 8 of Rule 10 of the Rules 2017 applicable to the inquiry before the board. Here also, it is to be kept in mind that only because a child in conflict with law has been found fit to be tried as an adult, it does not mean that the protection of the child-friendly atmosphere are not to be provided in the Children's Court. Even if the Children's Court decides that there is a need for trial of a child as an adult, it shall follow the procedure prescribed by the CRPC of trial by sessions, but by maintaining a child-friendly atmosphere, and the final order passed by the Children's Court shall necessarily include an individual care plan for the child prepared by a probation officer or child welfare officer. Where child has been found involved in the offence, the child may be sent to the place of safety till the age of 21 years. And while he remains at the place of safety, there shall be yearly review by the probation officer or the child protection officer of the district child protection unit or a social worker to evaluate the progress of child, and the report shall be forwarded to the Children's Court. When the child attains the age of 21 years and is yet to complete the term of stay, the Children's Court shall interact with the child in order to evaluate whether he has undergone reformatory changes and can he contribute as a member of the society. After making the evaluation, the Children's Court may decide to either release the child forthwith, release on execution of personal bond, with or without sureties for good behavior. Several other measures are prescribed under the JJ Act and rules framed thereunder. Under Clause 2, Roman 2 of subsection 2 of section 20 of the JJ Act, if the Children's Court decides that the child shall complete the remainder of his term in a jail, then he may be sent to jail to serve the remainder of his term. We have by now understood the child's right to have a friendly inquiry and protective environment in course of such inquiry and trial. But $1 million question is whether the state and all other stakeholders are able to provide that atmosphere and protection. What are those issues and challenges which are staring at us till date? There are various challenges too. From my experience as a judge of the Constitutional Court, by virtue of dealing with the matters relating to the juveniles coming before me in a revision application setting aside of the orders passed by the appellate court and the JJ board, I find that despite there being all pious wish of the legislatures under the statute, the Honorable Supreme Court and the High Courts issuing several reformative directions from time to time, we have yet to achieve the goal. The issues will be briefly summarized hereafter. The first challenge before us is to sensitize the police officer dealing with the matters involving a juvenile. The setting up of a special juvenile police unit in every district and city with an intention to coordinate and upgrade the treatments of juveniles is the first and foremost issue. In this regard, Directions have been issued by the Honorable Apex Court in the case of Sampurna Bevra and others versus Union of India, reported in 2011 9 SCC 801 to the Home Department and Director General of Police. I have been informed that in the state of Bihar, till date, there is no special juvenile police unit. In the name of a special juvenile police, the DYSP at headquarter level has been made the head of the unit, and a station house officer of the police station has been notified as nodal officer. They remain in their police uniform and are simultaneously performing their regular duty as a police officer. Police officers are registering FIRs by giving exaggerated age of an apprehended juvenile, and they bring the juveniles in court for production together with hardened criminals. The attitude in khaki dress remains that of a powerful police personnel. Sometimes juveniles are brought handcuffed with the adult accused of crime. Imparting training to the officers posted in the special juvenile unit is another big issue and challenge towards creating a child-friendly atmosphere. Some of the issues which were identified by the Honorable Supreme Court in Sampurna Bevra case are still looking for the attention of the state government towards one, establishment of the juvenile police unit in every police station, their training and upgrading the police training manual. 2. Lack of infrastructure is one of the fundamental issues and challenges which we are facing today. I am told that in the premises in which the Juvenile Justice Board are functioning, there is no waiting room, much less a child-friendly meeting room for the child in conflict with law. There is no counseling room available where a child in conflict with law may meet his parents or a counselor. There is need of socio-psychologist, and under the Act and rule, the state has to prepare an expert panel of socio-psychologists. Instead, I am told that a child is sent to a clinical psychologist posted in a Sadar hospital, little realizing the difference in the clinical psychologist and a socio-psychologist. The psychosocial factors of children in conflict with law in Indian context are required to be taken care of. It may be individual factor, it may be family factors, and yet it may be community factor, and these are required to be studied, which may be done by a psychosocial psychologist. Therefore, it is high time for the state government to look upon this requirement, and by this conference and seminar, if the state government may be convinced about the requirement of the psychosocial psychologist, I think it would be a great gain today for all of us. Now, the next issue and challenge is appointment of social workers in this Juvenile Justice Board. The social workers are also empowered to conduct an inquiry independent of the principal magistrate in terms of the JJ Act, though the final disposition of the inquiry cannot be done without the principal magistrate. Therefore, a big responsibility has been cast upon the social workers to make a significant contribution during the course of inquiry and at the time of disposition. Thus, the training of the principal magistrate as well as the social workers is of utmost importance. Even the rules provide for the same. The nature of training required to the principal magistrates and social workers are to be structured in such a manner that it becomes meaningful, because the effect of such training would be vital and the same is likely to reflect in their depositions. They are required to be sensitized from the point of view of the child rights and related laws. The next issue is that there are large number of inquiries pending before the Juvenile Justice Board. Therefore, it is the obligation of the Juvenile Justice Board to sit on daily basis. If the inquiry remains pending for a considerable period of time, it serves no purpose. The quality of legal aid and lawyers who assist the juveniles in conflict with law is another issue that must be taken up at the earliest opportunity. Here I would like to convey my own experience while I was the inspecting judge of the Jammu Justice and I was inspecting the jail premises. One day I found from my naked eyes that a juvenile was lying inside the jail. When I inquired about the how the juvenile fell in the jail premises, nobody was there to reply. Then I came to know that even the legal aid lawyers who are there in the panel, they never remain present in course of production of the juveniles in the court of Chief Judicial Magistrate. And then the system is such that a police officer, whatever writes the age in the challan, that challan is produced before the court, and at that stage, no inquiry is made, even by the learned magistrate, and simply remand is permitted. So these are the big challenges we will have to address. Then another issue is about the role of the probation officer. Under the provisions of the Act and the rules, the duty of a probation officer and the role played by him are to be understood. An accurate social investigation report prepared by a probation officer would help the Juvenile Justice Board in passing an appropriate order in course of inquiry, as also at the dispositional stage. Since the role of a probation officer is very important in making sure that a juvenile in conflict with law gets proper opportunity to represent himself, and further that the Juvenile Justice Board conducts a meaningful inquiry with the aid of the reports submitted by the probation officer, it is necessary that the probation officer be also sensitized. Awareness program be structured for them to know them, their duties and responsibilities. By imparting appropriate training to the probation officer, we can assure a better child-friendly atmosphere and protective environment in course of inquiry. Presently, we find that only stereotype social investigation reports are coming. In the name of preparing the report, only few columns are being filled up, mostly based on perceptions of a probation officer. There is no scientific and psychological data-based study. Therefore, these are the issues which are required to be taken care of. Lastly, while summing up the topic, I understand that it may be safely stated that we require 3A for ensuring a child-friendly atmosphere by the stakeholders. 1. Attitude. To ensure that every process should be child-friendly. 2. Ambience. Attitude should be used to create ambience showing child-friendly atmosphere. And 3. Alertness. Every stakeholder should be kept alert that there should be child-friendly atmosphere while dealing with a child. And at the end, I quote what Barbara Bush, the former First Lady of the United States, said, quote, "You have to love your children unselfishly. That is hard, but it is the only way," unquote. Thanks everybody.
Thank you, Brother Rajiv Ranjan Prasad. The meticulous way in which the topic of creating a child-friendly atmosphere and protective environment during inquiry and trial has been dealt with is really remarkable. He has emphasized on 3 A's: attitude, ambience, and alertness for the stakeholders to always keep in mind while dealing with a juvenile. As a matter of fact, we are running a bit short of time. Therefore, I am just offering the floor to Honorable Mr. Justice Ashwini Kumar Singh to address us on the third topic.
Thank you, moderator, sir. I have been allotted 45 minutes in minute program. I don't know how much time I will get because of we are running short of time. Anyway, whether I am audible, brother?
Yes.
Yeah.
Yes.
Very good afternoon. The excellent speakers before me have focused on topics dealing with deinstitutionalization, right to bail to a juvenile in conflict with law, and the importance of creating a child-friendly atmosphere and protective environment while dealing with a child in conflict with law during inquiry and trial. I am sure that prior addresses made by Brother Ashutosh and Brother Rajiv has raised awareness on child rights, which would go a long way while adjudicating matters of children in conflict with law in the future. Their presentation style was superb, engaging, energetic, and educational. To take it forward, I would touch upon the issue that has generated a lot of debate amongst child rights activists, social workers, jurists, and lawmakers on the most contentious provision, that is Section 15 of the JJ Act 2015. Now, from here from, I would not refer the entire Juvenile Justice Act 2015. I would only address it as an act. So, Section 15 of the Act mandating the Juvenile Justice Board to transfer cases involving a child between 16 to 18 years alleged to have committed a heinous offence to a children's court is the issue over which I am supposed to have some discussion in this webinar. In order to better understand Section 15 of the Act, it is necessary to trace the concept, philosophy, and jurisprudence of juvenile justice system in India. Right from inception, the philosophy behind the juvenile justice system is to reform, rehabilitate, and reintegrate a child in conflict with law and a child in need of care and protection. Just like Brother Chakradhari, while moderating, said, since our childhood to the present age, we always have heard from our parents, and now we say to our child, chalo bachcha hai, galti ho gayi, sudhar jayega. So this is really a very apt quote coined by Brother Chakradhari, and this shows the entire aim and object of the act. Now, the first doctrine in dealing with children of both the categories is the doctrine of parens patria, which allows the state to step in and serve as a guardian for the children, the mentally ill, the incompetent, the elderly, or the disabled persons who are unable to care for themselves. With passage of time, the principle of parens patria shifted to the rights approach, focusing on the constitutional and procedural rights of a juvenile. The basic tenet is that a child in conflict with law should be treated in a manner consistent with the promotion of the child's sense of dignity and worth, which reinforces the child's respect for the human rights and fundamental freedoms of others, and which takes into account the child's age and the desirability of promoting the child's reintegration so that they assume a constructive role in the society. Now, before the Juvenile Justice Act was formally enacted in 1986, I would take you to two of the provisions of the Penal Code, which was enacted in 1986, that is Section 82 and Section 83. Section 82 states children under the age of 7 years as doli in capex. That means they are not competent to do any crime. So there is no culpability up to the age of 7. Under Section 83, it is said that children between 7 and 12 years could not be presumed to be guilty and prosecuted if they had not attained sufficient maturity and capability to understand the consequences of their conduct.
The first legislation enacted for children in India was the Apprentices Act 1850, which was followed by a series of legislation in India to safeguard the rights of children. In 1897, the Reformatory Schools Act was enacted. The turning point in the juvenile justice system was the report of Indian Jail Committee 1990-1920, which led to adoption of the Children's Act in various states like the Madras Children Act 1920, the Bengal Children Act 1922, and the Bombay Children Act 1924. After independence, the Parliament passed the Children Act 1960, which was made applicable in centrally administered union territories and the states having no juvenile justice legal system. They were made free to adopt it.
Now, the necessity of a uniform Children Act across the country gave rise to enactment of Juvenile Justice Act 1986, which was influenced by UN Declaration of Rights of the Child in 1959 and UN Standard of Minimum Rules, that is more importantly, and it is generally said as Beijing Rules 1985. The detention of juvenile in police lockup or jail was abolished by the 1986 Act. It also recommended to establish juvenile homes for the reception of neglected juveniles, special homes for reception of delinquent juveniles, and observation homes for the temporary reception of juveniles during pendency of the inquiry and trial, and aftercare homes for the purpose of taking care of juveniles after discharge from observation homes or special homes. The object of 86 Act was to protect juvenile from criminalization, penalization, and stigmatization. This repealed various Children's Act established in different states and provided a uniform juvenile justice system in India, which categorized boys under the age of 16 and girls under the age of 18 as juveniles. Noticing various shortcomings in 1986 Act, when India signed and ratified the UN Convention of Rights of Children in 1992, the 1986 Act was repealed and replaced by the JJ Act 2000, which came into force on 1st of April 2001. The 2000 Act defined the term juvenile as a person who has not completed the age of 18 years. So the distinction in the 86 Act regarding age of juvenile of a girl child and a male child being 18 and 16 was abolished by the 2000 Act, and under this Act, no child for any reason could be lodged in a police lockup or in jail, and any police officer or special juvenile police unit or the designated police officer had to hold an inquiry in the prescribed manner And after inquiry, if the committee was of the view that the said child had no family or ostensible support, it could allow the child to remain in the children's home or shelter home till suitable rehabilitation is found for him or till he attains the age of 18. The legislature arrived at the position that an individual below 18 years should be dealt with or treated as a child in need of care. Further, the 2000 Act prohibited imposition of death penalty, sentence of imprisonment, or use of jails or police station for keeping children under any circumstance. The position that children below 18 years should be dealt with or treated by providing them with psychological support and opportunity to reform continued until 2015. After the brutal gang rape and subsequent death of Nirbhaya in 2012, there was debate that the provisions and system of the Act of 2000 are ill-equipped and needed modification to tackle the children in the age group of 16 to 18. After an extensive debate on this issue, the Act of 2015 came into force on 15th January 2016. It governs children alleged and found to be in conflict with law and children in need of care and protection. Brother Rajiv has pointed out that it classifies offences in three categories: petty, serious, and heinous. Now here, while addressing you, I am concerned with heinous offences. Heinous offences are those offences for which the minimum punishment under the Indian Penal Code or any other law is imprisonment for 7 years or more. Earlier, there was some confusion, and therefore, I'll say with my experience that in many of the cases where the minimum punishment was not imprisonment for 7 years or more, cases were being transferred because the punishment was more than 7 years. So I had an occasion to deal with one matter, and in that case, I had decided that no, the Act mandates that unless the minimum mandatory punishment is 7 years or more, a child cannot be said to be called to have committed a heinous offense, and therefore in his case, the entire procedure which is to be followed is the procedure to be followed by the board. After that, now I feel there is a Supreme Court judgment also on this point, and therefore now it is binding on all the high courts and the civil courts. Now I have also taken feedback. There is no more case where there is no mandatory minimum punishment for 7 years. The JJBs are sending the cases to the children's court. So that position has now become clear. Now, the Act of 2015 treats all the children below 18 years equally, except in the age group of 16 and 18 years who are alleged to have committed heinous offense. Section 15 of the Act enumerates special provisions to tackle the child offenders committing heinous offences in the age group of 16 to 18. This is an area where there is a lot of confusion, and therefore, while the committee was choosing the topic, the committee entrusted this task upon me to address in the webinar and to try to create clarity on certain confusions which are prevailing in our state. I think that in other states also the similar problem would have arisen. Now, what is the problem? The problem is the requirement to conduct a preliminary assessment to determine whether the child should be transferred to the children's court to be tried as an adult or not by the board is the area of concern. While undertaking the job of preliminary assessment, the board is mandated to comply with certain steps. Those steps are very necessary so that there may not be any case where a child need not be transferred to the children's court be not transferred. So what are those steps? I would just state you one after another. Firstly, the board must conclusively determine that child in conflict with law is above the age of 16 years but below the age of 18 years on the date of commission of the offence. The determination of age is very crucial for the child as the same has the potential to expose him to the possibility of being transferred to the children's court to be tried as an adult. Now, this determination has to be made as per Section 94 of the Act. Brother Rajiv has dealt with that provision elaborately, so I need not repeat those things. Secondly, if the board concludes that the child before it was 16 years or above but below the age of 18 years on the date of commission of the offence, it would be required to conclusively determine whether the offence alleged to have been committed by him is a heinous offence or not. The third step would be transfer of a child for trial as an adult can only be done after the preliminary assessment by the board. The word shall used in section 15(1) indicates that it is mandatory for the board to conduct preliminary assessment. The preliminary assessment has to be conducted to assess three aspects in respect of a child. The first being child's mental and physical capacity to commit alleged offence. The second step would be to assess child's ability to understand consequences of the offence. And the third stage would be to assess the circumstances in which the child allegedly committed the offence. After these three steps, after assessment is completed in respect of these three steps, the fourth requirement for the board is to further determine whether the board would like to deal with the case of child itself or transfer him to the children's court. These mandatory requirements are to be carefully conducted while determining whether a child should be transferred to the children's court to be tried as an adult or not. The legislature has provided that for the purpose of preliminary assessment, the board may take the assistance of an experienced psychologist or psychosocial worker or other experts. I am aware of the fact that there is dearth of psychologists or psychosocial worker, but I'll not say that there is dearth of other experts. In our country, there is a lot of talent, and talented people can be found in each and every district and subdivision. If we do not get psychologists, if we do not get psychosocial worker, if we endeavor, we would certainly get some expert dealing with child psychology. The board is required to take assistance of such experts in absence of the first two experts. Now, while saying something about section 15, I'll have to say something about section 15 also. It needs to be kept in mind that section 14 clause 3 of the act obligates that preliminary assessment in case of heinous offences under section 15 should be completed within 3 months by the board from the date of first production of the child before the board. So this provision has to be kept in mind always by the board. The board is also, and if the board is satisfied on preliminary assessment that the matter should be disposed of by the board, it shall follow the procedure as far as may be for trial in summons case under the CRPC. Now, if the board, after conducting preliminary assessment, passes an order stating that there is a need for trial of such a child as an adult, it may order for transfer of the case to the Children's Court having jurisdiction to try such an offence. Further, section 18(3) of the Act provides that where the board, after preliminary assessment under section 15 of the Act, arrives at the conclusion that there is a need for trial of the child as an adult, it may order transfer of the trial of the case to the Children's Court having jurisdiction to try such offence. Now, at this stage, the explanation to section 15 is also to be kept in mind. It provides that preliminary assessment is not a trial, but is to assess the capacity of such a child to commit and understand the consequences of the alleged offence. If the preliminary assessments are made casually by the principal magistrates and the members of the board, or without the assistance of trained and experienced psychologist or psychosocial worker or other experts in child psychology, such assessment would be counterproductive and would not be in the best interest of the child, which is one of the tenets under the JJ system. On the contrary, it would be more harmful to children. Unfortunately, I find that almost all the preliminary assessment reports received in my court are cryptic, uninformative, and I miss if I am being too harsh, I seek your apology. At sometimes it is arbitrary. I have often observed that these reports merely state that the child is mentally and physically fit and has the capacity to understand the consequences of the offence. Such preliminary assessments are meaningless. The principal magistrates and the JJB members should be proactive in asking for psychologist or psychosocial worker or other experts to help them in preliminary assessment for cases pertaining to child in conflict with law. Brother Raju has rightly pointed out that the state must also rise to the occasion and take necessary steps in order to provide panel of psychologists or psychosocial worker or other experts to help the board in making such preliminary assessments for cases pertaining to child in conflict with law. We in the JJ Monitoring Committee have continuously impressed upon the Additional Chief Secretary and Director of the Social Welfare Department to sensitize this government to immediately come into action in order to impanel a list of psychosocial experts, psychologists, and other experts so that the object of the act can be achieved. Now, the board itself is also required to use the provision emphatically and wisely to protect children from coming in conflict with law in future. The need is to keep in mind that every child in conflict with law was once a child in need of care and protection. A decision taken solely on the basis of inputs to the crime and the criminal can have a devastating effect on the life of a child who otherwise can be a contributing member of the society. Friends, all of us here have undergone our journeys which had influenced the decision that we may have taken, which in turn has defined the course of our lives. While we get acquainted with the offences committed by the child upon his arrival at the observation home, we often fail to understand the experiences which led him to commit an act, classifying him as a child in conflict with law. The preliminary assessment is a powerful tool to get a holistic understanding of the journey of the child in question and enables us to appreciate the circumstances that led to the commission of the alleged offence. If we understand the journey, we can identify specific interventions to address the issues that caused a given child to get into observation home. There may be a number of factors that render a particular child vulnerable, such as socioeconomic status, experiences of violence, school dropout, abuse, neglect, to name a few. Therefore, I urge the principal magistrates and the JJB members to discharge their duty of preliminary assessment with utmost diligence and sincerity. Once the case of a child is transferred to the Children's Court, a duty is cast upon the Children's Court to further decide the suitability of the child to be tried as an adult. Section 19 of the Act gives two options to the Children's Court: either to try the transferred child as an adult or not to deal with the child as an adult. Here, I would highlight one thing, and if the presiding officers of the Children's Court are here, I would specifically address them that I am yet to see an order where the Children's Court has decided not to try the transferred child as an adult and has conducted inquiry in case of a child having been transferred to the children's court by the board to be tried as an adult for committing a heinous offence. Now, it is the duty of the children's court when it comes before it to reassess the preliminary assessment made by the board and to come to a conclusion whether to try the child as a child or to try the child as an adult. In case the children's court decides to deal with the child as a child, it shall conduct an inquiry as a JJ board following the procedures for trial of summons case in accordance with the provisions of section 18. And in case it decides to try the child as an adult, it shall follow the procedures as prescribed by the CRPC for the purpose of trial by Sessions Court and pass appropriate orders after trial without prejudice to the provisions of section 19 and 21 of the Act, considering the special needs of the child, the tenets of fair trial, and maintaining a child-friendly atmosphere. Brother Asutosh and Brother Rajiv have talked about the potential of child which can be grown in a child-friendly atmosphere. They have in fact highlighted the various aspects, and especially Brother Asutosh has referred to the happenings all around the world where the children, if they have been given a child-friendly atmosphere, have proved to be not only a contributing member of the society, but they have excelled more and more than any other person or any other adult. Now, in this regard, I would like to add just one short thing. I'm referring to the officers presiding children's court is specifically in case of Bihar. These days, during pandemic, we are holding virtual court and we are hearing lawyer through video conferencing. Earlier, this roster of revision under the Juvenile Justice Act or appeal under the Juvenile Justice Act was never before me.
Brother Ashwini,
Yes, yes.
Sunil Singh, in fact, there is a technical issue because this meeting cannot continue beyond 1:40.
Okay.
So this is what the this is what. So in any case, this cannot go beyond. It has been fixed for 4 hours only. This is what the information which I have received. So
I'll try to conclude. I'll try to conclude fast. Yes.
No, brother moderator, we were told by the technician that they have the capacity to extend. Kindly tell them to do the procedure.
They have rather expressed inability. Therefore, the difficulty has arisen.
Okay, I'll try to conclude. Now, please. Now, I was referring to child-friendly atmosphere. I would just conclude in one line that child-friendly atmosphere can be created only if you give your designation as children's court. All the officers are mentioning themselves to be additional district and sessions judge come special judge POCSO Act. No, you are not additional district and sessions judge. You are not a special judge POCSO Act. When you are dealing with a child under the Juvenile Justice Act, you are children's courts. Therefore, you should use your designation as children's court and not as additional sessions judge. Now, leaving apart other things, Section 19 deals with preparation of individual care plan for rehabilitation of child, including follow-up by probation officers or the district child protection unit or a social worker. Now, 19.4 provides children's court shall ensure there is periodic follow-up report every year by probation officer or district child protection unit. I'm just concluding, Brother Chakdhari. I'll not take much time.
Yes,
On a reading of section 19 of the Act in isolation, it would appear that children's court may order for longer period of stay. In each case, insisting stay of child in place of safety till he attains the age of 21 years. And thereafter he shall be transferred to jail. However, if we read section 19 along with section 20, the impression would be quite different. Section 20 of the Act provides that when a child in conflict with law attains the age of 21 years and is yet to complete term of his stay, then children's court shall provide for a follow-up by the probation officer or district child protection unit or social worker or by itself. And the purpose of this follow-up is to evaluate if the child has undergone reformative changes and if the child can be a contributing member of the society. Such evaluation has to be made only if the child has attained the age of 21 years but has yet to complete the term of stay. Section 20 of the Act empowers the children's court to release a child. This is very important and crucial for our children, presiding officers of the children's court. Section 20 of the Act empowers the children's court to release a child from the place of safety without being sent to jail on attaining the age of 21 years. Now, at this stage, what would be relevant to be kept in mind is that though heinous offences include offences for which minimum punishment under the penal code or any other law is 7 years or more, on attaining the age of 21 years, children's court may release the child on such condition as it deems fit, which includes appointment of a monitoring authority for the remainder of the prescribed term of stay. Thus, the minimum imprisonment for 7 years or more in definition of heinous offense is only for the purpose of determining as to which matter should be transferred to the children's court. The general interpretation of section 15, 18, 19, 20 is that preliminary assessments are conducted in order to take decision for trial of 16 to 18 years old children to the children's court and to conduct trial of the child as an adult and to punish him suitably like an adult. But if said provisions are read together, it would appear that preliminary assessment is not only to make decision regarding trial, but to make decision that assist children with rehabilitation, reformation, and reintegration. The Act of 2015 has sufficient provisions to be able to aid child in conflict with law in a proactive manner so that their problems are alleviated within the JJ system. Now, having concluded myself on that point, on appeal, I will briefly say that section 101 of the Act talks about appeal. 101 has got 5 sub-clauses. 101 clause 1 provides that any person, 101 of clause 1 of this Act provides that subject to the provisions of Act, any person that is child in conflict with law, the victim or state, aggrieved by an order of board may prefer an appeal before children's court within 30 days. Suppose within 30 days it is not filed, then where will he go? The answer is proviso to section 101. It deals with the power to condone the delay caused in filing the appeal by the Court of Sessions. Now, the Court of Session has got no power to hear the appeal on merit. It can only hear the application for condonation of delay, and the Act mandate that such application has to be decided within 30 days. Section 101 का clause 2 जो है, that makes provision for appeal against the order of JJ board passed under section 15 of the Act after making preliminary assessment into heinous offense. Now here the appeal will lie before the Court of Session and not before the children's court. And the another very important aspect of the matter is that here the Court of Session can take assistance of experienced psychologists and medical specialists. But these psychologists and medical specialists should not be the same whose assistance was availed of by the board in making preliminary assessment under the Act. Now, here again it is important to note that if no appeal is filed and a case is transferred for trial to the Children's Court by JJ Board, the Children's Court is mandated to make its own inquiry to determine the suitability of the child to stand trial as an adult under Section 19. 101 Clause 3 prohibits appeal against an order of acquittal made by JJ Board except in case of heinous offence where the child has completed 16 years of age. 101 Clause 4 provides it prohibits filing of second appeal from any order of Court of Sessions, and Clause 5 of Section 101 provides that any person aggrieved by an order of Children's Court may file an appeal before the High Court. Now, brother, I will take 3 minutes more if you permit.
Yes.
3 minutes more.
Yes, yes.
Recently, while dealing with case under the Act, I found that appeals are being entertained on merits in several judgeships by session judges against orders refusing bail by board. Since Session Court has no jurisdiction to entertain an appeal on merit against an order granting or refusing bail by the board, the order passed by Sessions Court on such appeals are quorum non judice, that is, without authority. Similarly, I have come across several cases where appeals are being filed before the Children's Court and are being entertained by them against the order of preliminary assessment. Such appeals again are not maintainable before the Court of Sessions. Such appeals are maintainable before Court of Sessions and not before Children's Court. Therefore, the orders passed by Children's Court in such appeals are without jurisdiction. Further, I have come across cases in which Children's Court has remanded the case of transferred child to the board while hearing an appeal or even otherwise. Firstly, an appeal against an order of preliminary assessment is not maintainable before Children's Court. And secondly, Children's Court has not been conferred with jurisdiction to remand the case of transferred child to the board. If the Children's Court forms an opinion that transferred child is required to be tried as a child and not as an adult, instead of transferring the child to the board, it can itself hold inquiry, as I have discussed earlier. I apologize for taking, brother, so much of your valuable time. However, I end my speech with a hope that we create a more congenial environment for the future of children, especially those in the conflict with law. Thank you. Stay home and stay safe.
Thank you, Brother Suni Singh. I am just handing over the floor to Brother Honorable Mr. Justice Amanullah because of the time constraint which we are facing. I don't know how much this Microsoft system is going to support us. Please, sir. I am guilty of you, sir. I earnestly apologize for that. Please unmute, sir, your mic. You are still, yes.
Not required, brother. Everything is, they were more important. Mine is just concluding. Anyway, good afternoon, everybody, especially Honorable the Chief Justice. We are thankful that he has supported us and continued with us for so long, and all the attendees who have been following this webinar. Just a quick roundup. To sum up, you had a very intense session by the learned speakers. Even I've been enlightened, and especially with regard to Honorable Chairman, I've always felt that I've learned something from his speeches. Some of my concepts have always been more clear. Coming to the main issue of the task which I've been entrusted with, I would thank Saurabh for having initiated the webinar as we call it, and Brother Arvind Srivastava in his welcome address had addressed the questions with regarding to the holding of training. I think that is an important take, because nobody, especially the judges coming from the background of being trained and imparted training to be in a certain mindset have to be trained to be more accustomed and deliver what is required under the Act. Brother Chairman Justice Ashwini Kumar Singh, in his introductory address, had referred to the hardships of children, giving statistics with regard to the population. India, especially Bihar, has a very high number, and then it is all the more incumbent on us to focus because time is really running out. Honorable the Chief Justice in his inaugural address started with the experience he had after seeing the photograph of the two boys, and thankfully Justice Brother Chakradhari has been able to show us to us. The picture doesn't need to be explained. It really touches your heart, and I think by the time everybody got to listening the speakers, everybody was in a fine, because all the time in my mind I can confess I had that picture of those two boys always before me. It was coming, though it was not on the screen. So that was a wonderful way of really saying so many things and preparing the audience for what was to come. And Honorable the Chief Justice has emphasized, which I think everybody would vouch for that in the new generation, especially children, we have to instill an idea of respect for the Constitution. And that is only when we sensitize them and make them understand that as a child they may have committed some mistakes, but they are part and parcel of the society and they can contribute and they are required to contribute. But that is because only if we take care and respect them and show them that they are desired elements, they are not outcasts, they deserve the love and the society loves them and wants them back to contribute. So that is the challenge. How we deal it is left to all the stakeholders. Brother Ashutosh started with synchronization and right to bail. It was a very elucid speech by him. I was wrapped in attention giving all those examples. Well read, Brother Ashutosh. And thanks for sharing your reading experience, because I don't read, so through you, I get to know whatever is required to be read, all the relevant. You remove the chaff from the grain for me. Thank you for taking us through all those examples and all, and how there is abuse in the institutions. I think the very important take was everybody is aware that there is abuse, but hardly any effort is made how to address that. This is, unless we do that, that is the practical aspect. Everything was on paper. Paper, we lack nothing. All laws, everything. But how to prevent that? And I think the major emphasis of his was that institutionalization is by way of a last remedy. Otherwise, the effort has to be that he has to be integrated in his own environment. Firstly, his own home, otherwise foster, or in the community, somebody who can take care. And rightly emphasized by him that the government responsibility is to ensure that the person or the community which takes care of him has to be suitably compensated so that it can take care of that child. Without resources, he or she will not, or the community will not take care of the person. Further, the desirability of a robust gatekeeping. Another point made by him was that every child needs an individual child plan. That is very important because no two human beings are same. Every person, every child needs a separate, minutely planned future for him, which is to be done by the by the probation officers on a social report or whatever. But these things have to be done, and that is the key to the success. Once you have a special program only for a particular person, I think chances of success are much higher because it is customized. Coming to the speech of the address of Brother Rajiv Ranjan, the emphasis by him was how we conduct the inquiry and trial and what should be the atmosphere. He has rightly taken to the legal details what is in the law, what the law mandates, because we cannot act or do beyond the mandate of the law. He has taken us all those nuances of the law, which I think would be useful, because all our acts and parameters have to be within the framework of law, because we as the upholders of the law have to do all that. And further, he was emphasizing that there has to be segregation on the basis of varying parameters, including nature of crime. So at every stage, it is either petty, heinous, or serious nature. Everything has to be, and then also with regard to taking care of them, it has to be considered with regard to their age requirement, special requirement. Coming to brother Ashwani Kumar Singh's address, I think this concept was in our minds, in the mind of the committee for quite some time, which required that how to deal persons between the age of 16 to 18 years has not rightly been appreciated by our presiding officers of the children's court and even the JGBs for that matter. I think whatever he has explained and the law which is relevant in this regard and what is to be kept in mind stepwise, what is their right, the concept of not being totally bound by the JJB's recommendation. Am I being audible? Am I still continuing, or not being totally bound by the recommendation of the JJB and acting independently? I think there is where the children's court are much senior to the JJB also.
Brother Amanullah, we have enough time. You can continue.
Okay.
Now,
Thank
in
you,
fact, the
thank
time
you.
has been extended.
Oh, thank you. So I'm sorry, I'll not go back to what I have said. I'll continue from that. So I think Brother Ashwani had made a very good point, because ultimately it is the person who is passing the final order which has the effect on the child. Whatever you write, that will be law and that would be implemented. So your job, especially children's court, how to deal with them at that stage also, again you have to be conscious of your responsibility both towards the society and the law, that as a court which is acting basically as a guardian to reassess whether rightly the case has come to you, and if you have serious doubts, then record reasons and move. But how you do that, as has been explained by Brother Ashwani, that you have to do it within the parameters of law, which gives you the right under section 19 to try as an adult or not to do so by holding the inquiry as a summons case under section 18. So that is a very big power given to you. And even in the assessment, preliminary assessment, what is to be done stepwise, the JJBs, I don't think Brother Chairman was correct that I don't think we have been following, our JJBs have been following that with regard to that preliminary assessment under section 15(1) of the Act. It is very, very potent. You go through that. The words are very simple, only 3 lines: mental, physical capacity, ability to understand. But it is very, very important, and I don't think the JJBs are empowered in the sense that they have the capacity. So they should not feel shy of asking for expert help, because in everything experts are required. And to understand the ability, it is not by 2 minutes interaction that you can understand. So kindly be free, do that, because it's meant for a purpose. One order of yours will change life, either for good or bad, of the person who is an integral part of the society. Tomorrow he would be leading the nation. So that is a very important thing. I think we should not dilute that in any manner. Coming to what has been finally said, I would just sum up. Brother Chakadhari, you also need applause for peppering your moderation with your typical comments. And yes, congratulations and thank you for the "bachche hai sudhar jayenge" cliche. I think that is the trick you've given us. But again, before summing up, I would also say that even adults, as adults, all of us, the stakeholders, should remember that ये कहना है ना बच्चे सुधर जाएंगे, but दूसरा बात ये भी एक क्लीशे है कि हर किसी में एक बचपन और एक बच्चा छुपा है, अपने में वो बच्चा जगाई है। आप सोचिए उसके लेवल पे जाइए कि अगर मैं उस पोजीशन में होता, ये क्राइम मैंने किया है, क्यों ये क्राइम हो गया होता, अपने वाला बच्चा जगाइए और उसकी मानसिकता में जाइए, तब आप समझिएगा कि क्या उसकी जरूरत है, उसकी नीड क्या है, वेदर वो सच में गिल्टी है या वो भूलवश है, वो समझ नहीं सका। अपने में बच्चा जगाइए, तब बच्चे से डील करिए उसके लेवल पे। Thank you so much. I think everybody would have benefited, and big thanks to the invitees who have suffered us for so long. But I believe that the fruits would have been sweet for you and will help you. Thank you so much.
Thank you, Brother Amanullah. Now the technical session is over. Probably the additional registrar shall deliver his vote of thanks.
Moderator, sir, I would like to intervene for a moment. Moderator,
Yes,
sir.
please do it, sir.
In fact, your command came that I have to conclude fast, and therefore,
Right, sir.
I concluded as per your command. Now I am seeking your permission for 1 minute only before the formal vote of thanks is given by Subhas, our learned additional registrar.
Please do it, sir, and please put your camera on.
My camera is off.
Yes.
Okay. Okay. I'm putting it on. The formal Thanksgiving is to be done by additional registrar Subhas. But I think that we have missed out one great name who is present on screen with us, and his none is Brother Vikas Jain. He and his team has given the technical support. It was under his able leadership. We got this webinar organized, and therefore, before Subhas wants to proceed with his formal vote of thanks, I must thank Brother Vikas for guiding the entire webinar from the background and coming on the forefront only on the final day. So he was keeping tab over everything. He was asking me every evening whether things are progressing well. He was directing his entire team that how things are to be organized. So I'm really grateful to you, Brother Vikas. I'm grateful to IT Registrar, Rupesh Dev. I'm also grateful to Nitesh, Senior Programmer. So this is one thing which I wanted to say while concluding my speech, but I have intervened. I'm sorry. Now I'm giving the mic back to you, moderator, sir.
Yes, Mr. Subhash Chandra Sharma, please deliver your vote of thanks.
Thank you, Lord. Good afternoon, everyone. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of the Juvenile Justice Monitoring Committee of Patna High Court, and on my own behalf, must mention our deep sense of gratitude to Honorable the Chief Justice for his Lordship's gracious presence in this event. My Lord, your very presence has suffused and encouraged each and every one of us with new stamina and motivation for continuing our work on juvenile justice, more particularly in the current challenging time of pandemic. As we all know, every successful event depends on its sound and flawless blueprint on which it is created. We are grateful to Honorable the Chairperson of the Juvenile Justice Monitoring Committee, Honorable Mr. Justice Ashwani Kumar Singh, for his Lordship's continuous guidance, support, motivation, and encouragement in designing this event and monitoring every details of it. By dealing with the topic, his Lordship's extensively covered the area of concern relating to a child in conflict with law who has completed or is above 16 years of age and is alleged to have committed heinous offence. The aspects relating to the appeal in such cases, which are extremely relevant for the children courts, have been candidly presented and elaborated to avoid any confusion on this topic. It will certainly help the children court and will be beneficial to all the stakeholders. Further, I express our sincere thanks to Honorable Mr. Justice Vikas Jain, who has been kind enough to grace this event and encouraged us with his Lordship's valuable suggestion, especially on technical issues. I would like to express our sincere thanks to Honorable Mr. Justice Ahsanuddin Amanullah, Honorable Member of the Juvenile Justice Monitoring Committee, for his Lordship's close scrutiny of the preparations for this event, as well as for his Lordship's motivation, encouragement, and providing opportunity to us to organize such event. His Lordship is known for his one-liner up to mark compact dose of suggestion. Continuing with the same style, his Lordship some of the topics of today's event, which will definitely act as a ready opener of the topic discussed in this webinar. I take this opportunity to especially express our deep regard and gratitude to Honorable Mr. Justice Chakradhari Saran Singh for cooperating us in this event. His Lordship's lucid style of setting the tone for each technical session and moderating the entire session in a most regulated manner has in fact tuned this webinar into an understandable presentation. I would further extend a hearty thanks to Honorable Mr. Justice Asutosh Kumar for giving an excellent coverage on topic related with the deinstitutionalization and best interest of the child, including his right to bail. His Lordship rightly talked about the requirement of attitudinal change among the stakeholders dealing with juvenile justice to get the desired result as mandated under the Juvenile Justice Act 2015. I am also very grateful to Honorable Mr. Justice Rajiv Ranjan Prasad for his Lordship's thought-provoking insights on the most important topic dealing with a child-friendly atmosphere. During judicial process under the JJ Act 2015, I am sure that it will help the stakeholders to understand the true connotations of child-friendly requirement while administering the juvenile justice law. My sincere gratitude also goes to Honorable Mr. Justice Arvind Srivastava, Honorable Member of the Juvenile Justice Monitoring Committee, for his Lordship's guidance, support, and motivation to us for organizing this event. We are thankful to his Lordships for giving a brilliant start of this event through welcome address. I'm also very grateful to Honorable Judges of the Patna High Court for getting connected with us and watching the entire event. And we also would like to acknowledge our gratitude to Honorable Judges of different High Courts for being with us and grace the occasion. I extend my sincere thanks to the Registrar General and officers of the Registry, Patna High Court, Director and other judicial officers of Bihar Judicial Academy, Member Secretary and other officers of the Bihar State Legal Services Authority, District and Session Judges, Presiding Officers, Children Court, Chief Judicial Magistrate, Principal Magistrates and other judicial officers who have taken pain to join this event from their respective places. I am thankful to Additional Chief Secretary, Department of Social Welfare, Government of Bihar, Sri Atul Prasad, Additional Director General of Police, Weaker Section, Sri Vinay Kumar, Director, Social Welfare Department, Sri Raj Kumar, Chairperson and members of the Bihar State Child Protection Society, all the range IGs of police, DIG, SSP and SSP, SPs, chairman and members of the CWC, ADCPU, probation officers and social members of JJB for joining this event from different places. Finally, I would like to take this opportunity to place on record our hearty thanks to Registrar IT cum CPC and his team, Senior Programmer, Patna High Court, staffs and officers of Juvenile Justice Secretariat, and especially to the officers and staffs of the Beltron for their perfect logistic support and their enormous cooperation in the organization of this event. I cannot thank everyone enough for their involvement and their willingness to take on the completion of tasks beyond their comfort zones. Once again, I want to state that we are all most grateful to all speakers on this platform. We thank you for being with us this afternoon. It's been a great pleasure. Have a wonderful day ahead. Thank you.